My lord, I have filed an constitutional affidavit, my lord. Matter paper may be called for, my lord. Today is item number 20, my lord. Supplement 20. my lord. Honestly.
May please the lordship, this matter may come up on Monday, the last order, on 14/3/2020, this come. For the last one year, it has not come, so madam may come on.
My lord, item number 4, my lord, I may be allowed to withdraw, my lord. Some development has.
Mr. R.S. Rohan, counsel for the petitioner submits that during the pendency of this petition, there has been some subsequent developments as a result of which he has instructions from his client to withdraw this writ petition. Full stop. The prayer is not opposed by learned counsel for the respondent. Full stop. In view of the above, you are appearing, Mr. Sharma. Prayer is not opposed by Mr. H. Sharma, learned Government Advocate Assam, appearing for the state. In view of the above, this writ petition stands disposed of on withdrawal. Any interim order is there?
No, my lord.
All right.
My lord, liberty may be.
No, what liberty? If there is a fresh cause of action, you are always
Yes,
at
yes.
liberty. Yes, yes.
My lord, I beg to mention for listing of the case, my lord, 16/12 last listed, last chance is given to respondent 4. After that, he will repair, my lord, so there is an urgency.
When do you
Otherwise,
want it? When?
Monday, next.
Oh, everybody wants Monday. Monday we'll go off somewhere else.
My lord,
You have all the cases listed and empty court.
then two is, what is?
All right, all right.
Okay, oblast.
May
Yes.
please the lordship, I pray for listing a repetition, it was listed on last 16/11.
You also want on Monday,
No, one is so 14 or 16 anything.
16.
Maybe your lordship,
Hmm.
I beg to mention for listing of IA lordship for
Hmm.
stay vacation.
Hmm.
Lordship matter may be listed on 9th lordship,
9th.
9th lordship, Thursday.
What is the matter?
Lordship, it's a promotion matter, my lord,
Oh,
assistant engineer to.
Next week, next week. Next week. Put a date next week. Yes.
Lordship.
May it please your lordship, item number 2 and 30 of the hearing list, my lord,
Hmm.
is led by my senior, Ms. Bibhuya, my lord. This
Hmm.
matters may be taken up in the next week.
All right. Yes.
Deeply.
May it please your lordship, I beg to mention for listing for the motion space.
Hmm.
Matter relates to service matter. Similar situated candidates have been already appointed and petitioners have not been appointed.
When
Even,
do you want it?
On 10th coming,
10th.
yes.
Yes.
Yes, sir.
May I please your lordship, I beg to mention for listing of WPC number 5417 of 2022.
Hmm.
Any
Listing for what?
for admission lordship,
Next week.
next week. Much.
My please, your lordship, lordship, my prayer for listing this repetition and also for admission lordship.
Next week. Yes.
May it please your lordship, I beg to mention for a listing of matter.
Next week.
Oblige your lordship.
Next week.
Promotion item 1.
Lordship, I have placed one instruction.
Yes. Tell us
Actually,
what is it?
basically the social welfare department as such, they have written to the school education department
Hmm.
asking whether this degree, this certificate from the Nagaland High Secondary Education Council is recognized by the government of Assam or not. So I seek some time to actually get back because they have actually cited my emergency as an emergency case. So may I seek just 1 week time? By that next Friday,
So what has happened to the selection process?
it is otherwise going on actually.
Then you cannot finalize it. Hmm. They will not finalize it. We'll issue notice. Yes, I heard Mr. N. Ahmed, learned counsel for the writ petitioner. Also heard Mr. D. Bora, learned Government Advocate Assam, who has produced a copy of the written instruction dated 4/2/2023 to seek 2 weeks further time to obtain instruction as to the validity of the HS pass certificate obtained by the petitioner from a school in the state of Nagaland. Full stop. Mr. Ahmed submits that the respondents are going ahead with the process of selection and appointment of Anganwadi worker under the ICDS project, Dharamshala, as per the advertisement notice dated 30/8/2022. Therefore, an interim order is called for. Full stop. Issue notice of motion returnable on 1st of March 2023. Since Mr. Bora has appeared and accepted notice on behalf of all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the learned departmental counsel within 3 days from today, so as to enable him to. obtain-
served extra.
So as to enable him to obtain instruction and file affidavit. Heard on the prayer of interim relief, having regard to the facts and circumstances of the case in its entirety, it is provided that the respondents may proceed with this election, but shall not issue any order, but shall not finalize the same till the returnable date. A copy of the written instruction be retained in the record.
Obligement.
Charge employees since 94, 2004 service regular is personal, but order is different number. Page 22, your lordship says,
So we'll issue notice at this stage,
at this stage, notice and one post may be kept.
Lordship,
one post.
Post, because they have not, there are posts are lying vacant, they are not promoting it. 2 persons have been promoted.
So that's what they're saying. They are not promoting, so keep one post vacant. Is it not mutually contradictory? What do you say? You can submit, but when you write
There is
in
no
our
bar
order,
for promotion. There is no bar for promotion.
pendency will not be a bar. All right.
Lordship, may kindly have a look the order of this honorable court in similar matter. My senior,
No, I'm filing that case again. I have withdrawn that case with liberty to file similar matter, my lord, but I'm filing it again, my lord, that case. Because
You
I have,
obtain instruction, file your affidavit.
because of this, this post are regular under personal post, my lord.
Hmm.
This division bench of this honorable court already held as the
I've got this,
personal post are the ex-cadre post.
All right. We have to consider it.
My lord.
You're prepared to finally argue today, then we'll take it
No,
up.
my
today.
lord.
Otherwise, you file your affidavit.
My lord,
At this stage, I'm only issuing notice,
My-
but giving a fixed date.
lordship.
Giving a fixed-
pendency shall not be a bar.
No, not bar for, how can we say? If the law doesn't permit, then how?
Law, my lord, that is totally different. On the face of it, I'm showing page 22, my lord, it is personal to the incumbent till he retires or promoted. This is a different, and similarly situated persons have been promoted. My lord. Persons who were, my lord, regularized with the petitioners, they were promoted. It is not that, it is personal, my lord, but it is subject to.
All right, heard Mr. B.D. Das, Learned Senior Counsel, assisted by Ms. B.B. Hussain, Learned Counsel for the writ petitioner. Also heard Ms. M.D. Bora, Learned Government Advocate Assam, appearing.
Standing council transport department.
Learned Standing Counsel, Transport Department Assam, appearing for the respond numbers.
All the recommend.
Finance also here.
Oh, no. Fine, court, I am not appearing.
Then why did you say all the respondents?
Sorry, my lord.
Respond numbers 1, 2, 3.
Lordship may record Big Ogo's name, I will inform him.
Mr. B. Gogoi, Learned SC Finances appeared for respond number 4. Full stop. The petitioner is aggrieved by non-consideration of his case for promotion to the next higher rank of
Section assistant.
section assistant. Full stop. Mr. Das submits that similarly situated persons have already been promoted. Full
Posts are
stop.
lying vacant.
Notwithstanding the same, and despite the fact that the posts are still lying vacant, no action has been taken by the authorities to consider the case of the writ petitioner for promotion. First of, Ms. M.D. Bora, Learned Standing Counsel, Transport Department, on the other hand, submits that the petitioner was appointed against a post which was personal to him, and therefore his case cannot be considered for promotion. First of, be that as it may, after hearing the submissions advanced at the bar, this court is of the opinion that the matter would call for deeper examination. Issue notice of motion returnable on 10th of March 2023. Since the respondents are already represented, no formal notice is required to be sent. Extra copies of the writ petition be furnished to the Learned Departmental Counsel, requisite in numbers so as to enable them to obtain instruction and file affidavit. Heard on the prayer of interim relief, having regard to the facts and circumstances of the case, it is hereby provided that pendency of the writ petition shall not be a bar for the respondent to consider the case of the petitioner for promotion in accordance with law, if other similarly situated persons have already been considered under the rules. Full
My
stop.
lord.
Same order in the other matter also.
Yes,
Area of parties also same.
my lord.
Yes, same. Yes. List along with item 2. See your order, do list along with item 2. Yes, please.
Similar order will go on.
Yes, yes, yes.
Deeply obliged.
By showing the name of Learned Counsel for the respondents, yes.
Obliged. Supplementary list. Item 19.
Lordship, I have an instruction to appear, Lordship, in this matter on behalf of respondent number 14, Your Lordship. I am spraying from the petitioner side, Lordship, a copy may be served, Lordship. The petitioner, Mr. DK Das, is gone.
But petitioner is not present.
I'm also saying that matter is taken away at 2 o'clock.
At
I
2
can
o'clock.
read the, I have not read the petition, ma'am.
But they are not even present. What to do?
Lordship, we'll take a copy from them, Lordship. DK Das sir will be very.
Maybe they don't, they are now afraid since you have appeared and they don't want to pursue the matter.
Lordship may take up after some time.
All right.
Within the-
Passed over.
Much.
Item 5. Orders. Item 5.
Who is appearing in item 5?
And for APS.
Lordship, this matter pertains to Lordship, we have challenged the APSC, Lordship, select list, Lordship.
This is an application for vacating stay.
Lordship, we have not, we have for the writ petitioners, Lordship.
Who has filed the stay vacating
There
application?
are two vacation petition, one by the candidate, one by the government. One by the selected candidate, one by the government. Department.
But where is the government?
And in my impression, Lordship, Mr. Lordship,
We have
Lordship,
different
AG was.
AG, but he argued.
But he's not around. Passed over, we'll see if time permits. Yeah, next matter.
Much of it.
Apology, my lord, that item number supplement is 19.
It will come at the bottom of the list. Yes,
It will be taken up at 2 o'clock, my lord.
we'll see. Let it be called.
For admission, item 6 and 7.
May it please, Lordship. My lord, this item has come for final disposal because my lord, the matter is of 2015 and the petitioner before your Lordship, he was terminated from his services and the termination order is under challenge. And in the meantime, my lord, on 1st of July 2021, his normal superannuation date is also over. So, if your Lordship, may I proceed now or should I wait for the other urgent matters to be taken up?
It is absolutely your discretionary jurisdiction. You exercise your discretion. You want to do it, we'll hear you. If you want to wait.
I am ready to.
So, Mr. Kaur, what can we say? You want to argue, you argue. If you don't want to argue.
No, I want to, I'm ready to argue, but it's subject to the honor.
But why
convenience of the-
this matter should be taken up in admission? Why should?
Because the respondent number, the private respondent in this case, 7, she is my wife. So she has now come before this honorable court saying that whatever retirement benefits that I have to get, basically here the provident fund and gratuity has to be paid to me in terms of the earlier orders of the court. Now she says that I have an orders from the courts below. So I want a share from those terminal and retail benefits I have to
This is
pay.
a matrimonial dispute.
That's another. So it has no. My basically, so far I am concerned, my dispute is it All India Limited. But since he wants to be a part of it, and during the mediation process also, I gave a proposal that 50% of my provident fund and gratuity, I'll keep it, and the rest I.
So she is a estranged wife.
Yes. Yes.
There is a separation.
No. Officially there is on as per
No.
law there is no separation.
So why 2 writ petitions?
Well, one was filed because what has happened during my period of suspension, when the subsistence allowance were paid to the to my joint account with my wife, she used to withdraw the entire money. So I did not get a penny. Then I came before this honorable court saying that it should be transferred to my individual account, then there was a direction from this honorable court that it should be that the money should not be deposited in the joint account. So she came before this honorable court earlier also seeking a modification of the order. That order was not interfered. So far the money is concerned, it is status quo has been maintained. At that particular point of time, I think in 2018 or 17, that amount that time the All India said that around 58 and odd lakhs were due to me. But now they have come up with a statement. My wife has come out with a statement who that she has her own inquiry from the All India, and she says that now this has increased more than 1 crore rupees. So during the mediation process,
So just a minute, the petitioner was serving where?
in All India Limited as a doctor, and at the time of suspension, he was the officer on special duty.
He was suspended or terminated?
Initially suspended, the suspension was upheld. They're saying that there is no cause for intervention. We came before this honorable court challenging the order of
Just a minute, just a minute. Termination order is dated?
My lord, just a moment. Your lordship will first take the background, my lord.
No, have
They-
you
yes.
got a list of dates?
List of dates in the petition itself is chronologically given, even the index is chronologically given, my lord. Even the list of dates is chronologically given. I have given the list of dates chronologically only, but since your lordship will kindly take note of the dates only or once, because the suspension was of order was of 27/6/2013.
27?
6/2000.
So in your list of dates, 27/6/2013 is not even there.
But
You are
it's-
starting from 24/7/2013.
No, madam, just a moment, madam. My lord, just a moment. Suspension and dismissal. Just a moment.
Mr. Kaur, I think
Yes.
it will be better to have a proper list of dates.
Date of suspension is 21/6/2013. Order is of 27, but the suspension is 21/6/2013. Order is of 27/6/2013, my lord, and the dismissal from the service order is of 16/9/2014. That is annexure 19 at page 97 of the. Your lordship will take up the writ petition number,
So who is appearing for 1 to 6?
my lord.
You are appearing. And Mr. Bora?
Yes, my lord. I am for the respondent wife, my lord.
Okay.
My lord, what happened, my lord? I may be,
Mhm.
my lord, what happened actually, my lord? The wife initially filed a domestic violence case, my lord, against the petitioner, my lord. And in the domestic violence case,
Mhm.
my lord, by order dated 12/12/2013, there is a direction, interim direction by the Judicial Magistrate First Class
Mhm.
to pay 25,000 and 10,000 to siblings
Mhm.
accordingly. That was the direction. Interim order was passed, my lord. Not a single farthing was paid to both the children, my lord. Thereafter, my lord, as he has not paid, rather he has withdrawn some amount from the account, the 1,50,000 from the joint account, the petitioner, my lord. Then we have intimated to that fact to the JMFC, my lord, in the DV Act. Then accordingly, the JMFC directed the Oil India Limited to deposit 40 lakhs as a terminal dues
Mhm. Yes.
to keep it with them money, 40 lakhs. That was the direction by the Judicial Magistrate First Class under section 20 of the DV Act. my lord. Now, the suppressing that fact, there is a direction by the DV Act. They filed a writ petition without mentioning about that particular direction by the particular code. They simply came before this honorable court that the wife has taken withdrawn some amount. So that the joint account, money should not go. Rather, there should be a different account maintained by him that should be kept in that particular account. That was his initial prayer in the first writ petition, my lord. So he got an interim order. So by suppressing the order.
Which is that writ petition? What is the number?
WPC number. WPC 5207/2014.
Yes.
9/10/14 is dated 9/10/2014 is the order, interim order.
But by way of suppression.
It was absolutely by way of suppression, my lord, that order has been
Item number 7.
in item number 7. Yes. Then, my lord,
Final order again.
he has contested, my lord, in the DV Act. Then again, they have suppressed that fact that there is an interim order, the status quo has been given by so the DV Act continues, that has ended into the finality, and the final order, again, the same order has been directed by the Judicial Magistrate First Class in the DV Act, that the money should be kept in the,
No, money should be distributed.
money should be distributed.
DV Act orders are to be taken up in a writ petition or in a criminal petition.
No, no,
It
that's
has to be taken, suppose,
So, my lord, what happened, my lord? So DV Act order was there. So suppressing that fact, what was his initial prayer? Not to take away the money, to deposit the money in his own account, not in the joint account. That was his first writ petition. Then the DV Act finally disposed of the matter with a direction to the Oil India that the money should be distributed accordingly to the both the siblings, my lord,
And the wife.
and the wife. That was the direction to the Oil India. Then they have filed a second writ petition. In the second writ petition, also suppressing the fact of the order passed by the DV Act, he has again said that the money should be kept in a different account, that is in the HDFC Bank maintained by the Act.
What is the second writ petition number?
WPC 3603 of 2015, 05 of 2015.
And Lordship will see the interim prayer
And there is an interim pair
in the writ petition.
in the writ petition. The writ petition is basically that the money should be.
But he is saying the order of termination is under challenge.
That is a different issue, my lord. Our concern is because of these all interim orders from 2013 onwards, my lord, we have not paid a single farthing because of the stay order is operating against the oil. So oil also cannot disburse the amount in the account. So we are only on that part because we have not made the party in the writ petition. So we have entered our appearances because of this, because though there is an order by the competent court in the DV Act, which has been challenged by him in the appeal also, which has been dismissed because of the delay. Then he has preferred.
All right, we'll hear it, but it'll take a little time.
So our contention is that should be initially cleared by this court so that I can get the money. Because 2013 onwards, not a single farthing has it played to me.
But is there any IA to that effect? No.
Yes, we have filed an IA to that effect.
my lord,
We have filed an IA because they have not made us a party
No, my
in
lord,
the initial cases.
factually, my friend.
They are
is wrong.
suppressing everything, that there's a DV Act is going on, there's a direction in the DV Act.
All right,
So
so
by-
we'll take up the matter. Let us just finish up some part one cases and then we'll take up. We'll call up after some time. Yes, call up after some. We'll hear the entire.
Yes, ma'am.
Yes.
Well, in this case, we have filed an affidavit on 1st of February. The affidavit has not been tagged now.
We have got a copy, affidavit by the petitioner.
Because there is an industrial dispute act, we have challenged the order of restoration of service.
Mr. A. Das, Islamic Council for the Writ Petition submitted that the rejoinder affidavit on behalf of the writ petitioner on 1/2/2023 is not tagged with the record of this case. First up, Mr. K. L. Gupta, Islamic Council for the respondent member is present and submits that he has received a copy of the affidavit. Be that as it may, since the rejoinder affidavit filed on 1/2/2023 is not on record, the registry to trace out the same, tag this affidavit with the record of this case and list the matter again next Tuesday. Give the date. Next Tuesday is 14th. Yes.
Item 9 is wrongly listed, item 10.
May I please, your lordship, in this matter, I already say affidavit sent for vetting, my lord. During the course of the day, we are going to file affidavit. Matter may be come up after
The
1
matter was fixed by your lordship for disposal. They have sent the affidavit for vetting.
All right, if it is filed by today, then only it
Yes,
will be
yes, my
accepted.
lord. We are
Otherwise,
going to
no
file.
affidavit.
Yes, my lord.
Heard Mr. Ayed Sekar and counsel for the writ petitioner, also heard Mr. L. Datta, learned counsel appearing for the respondent bank.
My-
Is it therefore?
PNRD, my lord.
Learned standing counsel PNRD department Assam submits that affidavit on behalf of the department will be filed during the course of the day.
My lord.
And therefore, this matter be taken up again in the next week. First of Mr. D. Bora, learned government advocate Assam is present on behalf of the state.
Respond
On-
number 3.
Respond number 3, state oblique respond number 3. On an assurance given by Mr. Datta that the affidavit will be filed during the course of the day by serving advance copy upon the petitioner's counsel. This matter stands adjourned to 16/2/2023. It is made clear that if the affidavit is not brought on record on or before during the course of the day, the same shall not be taken on record.
My lord. Oblige,
If the affidavit is not filed during the course of the day, the same shall not be
Right.
taken on record.
oblige.
Item 11.
Here, your lordship, we have sent the affidavit for vetting from
Already filed. You have already filed it.
For whom? For respond number? For respond number 4. 4 has already filed an affidavit,
Already filed it.
but somehow it is not mentioned in our records actually. That's why.
Well, otherwise the pleadings are on record. It's with regard to constitution of a commission, electricity commission board. The licensing board, my lord, with regard to the post of secretary. The respond number 5 was appointed. I made a challenge to that, saying that I'm senior to her, this, that, and they say that I don't have the qualification even to hold the post of senior inspector. The lordship can take it up for final disposal any day conveniently, my lord.
Agree on a date?
My lord, any day, convenient to your lordship next week or the week next.
Next week, not
The
possible.
week next, my lord,
28th February.
28th.
Heard Mr. Yukenai, learned senior counsel appearing for the writ petitioner, also heard Mr. D. Bora, learned government advocate Assam appearing for respond numbers
Respond numbers 1, 2, 3, 4.
1, 2, 3, 4, and Mr.
RJ Das
R. K. Das, learned counsel for respond number 5. Stop, it is submitted at the bar that this writ petition is ready as regards pleadings, and therefore the same can be taken up for disposal at the stage of admission hearing. In view of the above, and on the request of learned counsel for the parties, registered to list this case again on 28/28/2023 for admission. Yes.
First September.
Item 12.
May I raise a question?
Lordship, may I please, your lordship, about like further 2 weeks time to file our affidavit, lordship.
Yeah, for whom?
I'm for the forest department.
Mr.
A Chakravarti.
A. Chakravarti, learned counsel is present on behalf of the petitioner. Mr. S. N. Hassan, learned standing counsel forest department makes a request to grant 2 weeks further time to file affidavit. Prayer is allowed. Let this matter be listed again after 3 weeks. In the meantime, the affidavit be brought on record. Interim order passed earlier to continue.
Item 13.
Your lordship, this is a matter where the petitioner, without giving a reasonable opportunity of being heard, straight away been removed and removed away from the service. Actually, the entire fact is, your lordship, that it was an evening when the petitioner was on a duty in the sick line at the railway, where he found that the 2 or 3 persons together, they are coming with some suspicious bag. The petitioner is an RPF constable. He apprehended those, but at the same time, from somewhere, the civil police, means the state police, they got a tip of that suspicious bag. They came, and along with that suspicious person, they arrested the petitioner without informing the superior officer. As because the petitioner belongs to the RPA and governed by the Central Police Force. And without any information, thus on the
Who
next
is
day,
appearing for the respondents?
I think Miss S. Barua for railway.
But where is she? Ms. S. Borua for railway is not to be seen. We wanted to know why it is not reasonable or practicable to hold
Yes,
an inquiry.
yes, yes.
There's no one from the railways?
So-
Anybody from the Indian Railways?
Nowadays, railway is being looked after by the central government. Earlier, it was.
That's right, but who is looking after the central government?
R.K. Dev Chaudhary, he is the SGI.
So he is not to be seen. We'll have to direct personal appearance of the officer. What else do we do?
He cannot.
Yes, tell us why it is not reasonable or practicable to hold inquiry. You are appearing.
My lord, brief, brief is not, record is not written, brief, my lord.
No, are you appearing in this case?
I will inform the architect, so they prepared, my lord.
Please do it. We'll pass an order in 5 minutes. It is up to him whether he wants to come. We'll record it in the order. You tell him, send him the information.
We are pressing for the interim, your lordship, because there is sufficient grounds and we will satisfy this court.
You tell him.
Timing, I'm.
You inform him. Let him place the case. Yes.
Your lordship, I will just bring your attention to one of
Yes,
the
you
judgments.
please take your seat. Let me go through the synopsis first.
As who was it? No, I see.
Where is the order dated 24/3/2020? Which page? Page
It is
number?
at page 35. 24 March 2020. Your lordship may see page
Yes,
36.
You please take it. We'll just go through the order and then.
Yes. Yes.
May I please, Lordship?
Hmm.
I will going to file affidavit during the course of the day. Affidavit is ready, Lordship.
Hmm. No, just wait a minute. Let us see what is the matter first. So there is some proceeding against the petitioner
Nothing.
under NDPS Act.
No, not at all. There is a trial going on.
Trial going on.
Trial is going on before the district court.
Hmm.
But I will place some of the relevant portions of the trial. I have obtained the certified copy,
Hmm.
and where it is very much clear that nowhere the petitioner is associated with.
No, that's all right. What is the interim order you are seeking today?
I'm just intending to stay this order, removal order, straight away removal order.
That can be-
Otherwise, the family is there, your lordship.
No, we can go for an early hearing, but
Yes.
removal order of March 2020 cannot be stayed today. If you are insisting, then I can write a long judgment. Otherwise, let her file the affidavit. We'll fix it for disposal after 2 weeks. If you succeed, it will be set aside, otherwise it will be maintained. Interim order is not possible. You have two options. If you want a detailed order, if you want to prefer an appeal, then I can write a detailed order. Otherwise, there's no point putting in efforts in that.
No,
After 3 years, interim order of stay on removal from service is not possible.
no, because your lordship, due to the ill advice, the petitioner directly went to the Allahabad High Court and they filed a writ petition.
Right.
And thereafter, the Allahabad High Court said that we don't have the jurisdiction, and he was at liberty to approach this.
No,
court.
we understand. We are not against the petitioner for the delay. Only thing is, under the legal fictions, the order you are asking for is not possible. We can either give a detailed reason why it is not possible, or we can fix it after 2 weeks, let her file the affidavit.
But your lordship, there is also a settled principle
Hmm,
by virtue of that Tulsiram Patel judgment,
hmm.
that even though the conviction is there, no one can be suspended directly, straight away. And your lordship, I will just place one thing.
Hmm.
Just I will take only 2 minutes. Yes.
What is the stage of the trial? Is he in custody?
No, they are on bail.
They are on bail.
They are on bail.
Hmm.
Your lordship may see, I have given a bundle of judgments and things. Your lordship may see one judgment of the Supreme Court of India.
Yes.
And paragraph number 9
What
of
is,
that
what
judgment.
is the, which case? Give me its title. of
This is
the case.
a Director General Railway Police Force versus Jayant Rajibhai Tande.
That judgment is not here.
It is
You
there,
have
your
given-
lordship. Union of India and others versus Ram Bahadur Yadav.
That is there, yes.
That is there.
Hmm.
Paragraph number 9 of that judgment. Very recent judgment, Your Honor, your lordship. Paragraph 9,
Hmm.
if your lordship may allow me to read.
Yes, yes.
It goes with, from a reading of the above said rule. That means the rule 161,
Hmm.
the entire rule. It is clear that to pass an order as disciplinary measure by adopting a special procedure in certain cases, rule 161 itself mandates recording of reason. The normal rule for conducting an inquiry is governed by rule 132, 148 and 153 of the RPF rules. If the authorities invoke a special procedure, unless they record reason as contemplated in this rule itself,
Hmm.
no order have been passed by invoking rule 161. At no point of time, appellants have produced file to show that any reasons are recorded in such file also. It is a settled legal position that when rules contemplate method and manner to adopt a special procedure, it is mandatory on the part of the authorities to exercise such power by adhering to the rule strictly. Dismissal of a regular member of a force is a drastic measure. Rule 161, which prescribes dispensing with an inquiry and to pass order against a member of the force, cannot be invoked in a routine and mechanical manner unless there are compelling and valid reasons. The dismissal order dated 20, that means the petitioner's order, does not indicate any reasons for dispensing with inquiry except stating that the respondent has colluded with the other head constables for theft and not non-judicial stamping. Here also the same thing has happened. Without invoking the rules of 153 and other thing, the authorities have straight away applied 161 sub rule 2 and straight away removed from the service. And after this judgment, your lordship will find there is a Government of India Ministry of Railway Board notification.
Yes.
Here it says where all the directions was been made from the railway board itself to all the principal chief secretary, security commissioners and all the other authorities. On pursuit of the court order dated cited above, it is advised by the competent authority to desist from initiating action under Rule 161 of the RPF rules, except when action under Rule 153 is not feasible. Whereas 153 rule itself mandates and clearly says that
Listen to me. The reason I will not pass this order is because this kind of a prayer cannot be made. You listen to this, it will help you in other cases because you are in practice. Huh? I will pass the order, I will. But for you, it will be important. When there is a removal from service, interim stay of that order does not bring your client to job. Half the lawyers in this courtroom
Yes,
knows
yes.
about this law.
yes,
So and somebody who is informed in law would have straight away said, give me an early hearing, set aside this order. The question of passing an interim order does not arise. If you want, I'll pass a detailed order, but not give you an early hearing, in which case you have to go on filing appeal. It is for the benefit of your client. I said, within 2 weeks, I'll fix a date. But even notice has not been issued in your case.
no, notice is.
Which is the order by which notice was
Last date
issued?
notice.
Give me the date of the order.
It's not issued.
Give me the date of the order. You must first know what is your case.
No, no, your
Give me
lord,
the date of the order by which notice was issued.
but it was dictated in
Give
the
me
open
the
court.
date by which order by which the notice was issued.
Last week notice issues, na, general. Court. Huh?
Notice issued.
Swati B. Borua, have the patience to understand what the court is saying. Huh?
Yes,
Otherwise, you will come and sing your song, we'll pass our orders. If that is what you want, we can do it. But we try to do justice. You have to
Yes.
also understand. You have to also understand how the law works.
yes,
An order for removal of service, unless it is set aside, the question of the person getting reinstated does not arise. That's the law. And by an interim order, he cannot be brought back. He dehoes the facts. But prima facie, we want to know from them in the affidavit why it was not practicable to hold an inquiry. So she said she wants time till
2 days, I
2 days. Yes, let her file it. You examine it. Don't be emotional. Legal matters has to be argued legally,
Yes, yes,
correct?
yes.
So you take your seat. We'll issue notice today. No notice has been issued in your case. It has been wrongly listed for admission. Because there is an order that notice is complete, but notice was not even issued.
yes, yes. your
Swati
lordship.
B. Borua, learned counsel for the petitioner is present.
It will proceed. Last.
All right, notice issued and completion same day. There is an order on the same day. Notice is issued and notice is complete.
Yeah.
All right, you partly have it then. Ms. S. Borwa, learned CGC, appearing for the respondent, submits that the affidavit on behalf of the department is ready and shall be brought on record within 2 days from today. Since the basic grievance of the petitioner is that he has been removed from service without holding an inquiry as contemplated by Article
311.
yes, 311 of the Constitution. The respondents are directed to bring on record the facts and circumstances which necessitated dispensation with the holding of inquiry so as to justify the order of removal. First up, since the petitioner is out of service and considering the urgency expressed in the matter by the counsel for the petitioner, registry is directed to list this case again on 23rd of February for admission hearing as a fixed item. The respondents would be at liberty to bring on record the affidavit on or before 10th of February 2023 by serving advance copy upon the petitioner's counsel. If no affidavit is filed on or before 10th February, the writ petition shall be taken up for final disposal on the basis of materials already available on record. It will be open for the petitioner to file rejoinder if so advised. An attempt will be made to dispose of the writ petition at the stage of admission hearing, parties to come prepared accordingly. You please take these judgments, keep it with you. On the next day, you place it, all right?
Yes, yes, sir.
And you also try to convince the court that when there is charge framed and the petitioner is facing trial under NDPS Act, how the order of removal, even if it is interfered with, what is the legal principle based on which he can be reinstated in service? So look at that law. The decision in Captain Paul McCartney's, it's Paul McCartney, is it?
Yes, 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 Lordship. And that is already guided by Tarsan Singh judgment.
Yes. So have a look at it and make a concise written note.
Yes.
We'll
yes,
take
sir.
up your matter for disposal on the next date. All right?
Obliged.
Okay. Okay.
Supplementary list for admission item 20.
But in this case, my lord, the petitioners were appointed in the year 1991, 94, 98, my lord, respectively, as additional mandal, my lord, under the establishment of the settlement officer, Dhubri and Kokrazar, my lord. Subsequently, my lord, there is policy decision to absorb them in the post of Lat Mandal under the deputy commissioner, my lord. But my lord, some similarly situated persons case has been already been my lord, absorbed, my lord, but our case has not been absorbed till that, my lord, due to the my lord, the objection raised by the BTC, my lord.
Lordship, last occasion, Lordship, I have placed one instruction, Lordship. 12 January 23. In this instruction, Lordship, it is stated that there is several trained RCC trainer.
What, sorry?
Several RCC trained persons, Lordship, who are seeking engagement. So regular process will be started, Lordship. They were appointed prior to creation of GTC, Lordship, by the Assam government, Lordship. So inability, they have expressed their inability, Lordship. Instruction is in the file, Lordship.
My lord, as per instruction, my lord, BTC, my lord, my learned friend want to say, my lord, that the records class course certificate who obtained, my lord,
No, no,
RCC
your
training-
clients were appointed as what?
My lord,
Appointed.
additional
mandals by
mandal,
the
who are
Assam
qualified as a.
Listen,
yes,
wait a minute. They were appointed pursuant to a selection process.
yes, my lord.
When was the advertisement issued? Where is the
My
advertisement?
lord, advertisement I have not, my lord, but.
No, then we cannot hear.
My lord, in the, there is a, my lord, mention in the appointment, my lord. Regarding, my lord.
I want to see the advertisement notice.
My lord, there is in the appointment order itself mentioned, my lord.
Can't write a judgment without these facts. You argue it, but we'll post it for another day. You have to show us the advertisement. What is the validity of the appointment? Unless that is established, the question of issuing a mandamus does not arise. How many posts were advertised? What are the norms? Was it a pay scale? Etc., etc. Then what process was followed? We'll have to see
My lord,
this.
in the appointment itself also, my lord, reflected, my lord. And let's see, my lord, is.
Not
is
possible.
Page 20, my lord, annex of 1, for the petitioner number 1, my lord, it is. My lord, reference number 2, my lord, this office advertisement number so and so, so and so, so and so, my lord. In all the appointments, my lord, regarding, my lord,
Where is the date? Where is the reference to advertisement?
Reference, no, in letter, reference.
Where is the reference to?
letter, my lord,
Serial 2.
serial 2, my lord.
Yes, so
It is,
advertisement issued in 1992
yes, my lord,
and your
And
client
I-
was appointed in 1992.
92.
Then how
92.
long did he serve? How long did he serve?
Doesn't that, my lord, petitioner is serving in the same capacity, my lord, as additional mandal.
Still serving.
Yes, my lord.
So what is the relief you are seeking?
My lord, our cases, my lord, see, there is a policy decision, my lord, adopted by the government that the mandals who are appointed as additional mandal, they have to appointed as Lat mandal under the establishment of the deputy commissioner, my lord. But in the year 2009, my lord, the state government already appointed, my lord. In the district of Lakhimpur, my lord. But due to local residents, my lord, this petitioner could not
What
join.
are you, sir? I've not understood anything. Your clients are working as additional lot mandal,
Additional, yes, additional Mondal, my lord, not
additional mandal.
Mondal, under the establishment.
What
of
do they want? Let us see what is the prayer.
Yes, my lord.
What is that they want?
Page 16, my lord.
Actually, you are seeking regularization.
My lord, absorption regularization, my lord. My lord, kindly see page 39.
Regularization or absorption?
Absorption, my lord. My lord,
Now address the court on what is the difference between regularization and absorption.
my lord, consequence of regulation and absorption are almost same, my lord.
Regularization is same as absorption.
My lord.
Where is the law on that? Where is the law on that? Why do you say so? Merely because you say so, it can't be the case.
My lord, kindly see page 39.
Lordship, they are seeking absorption as per annexure 5, Lordship, that document also incomplete. Kindly peruse annexure 5 of the writ petition.
So they are continuing in service.
They are
Yes, sir.
saying, Lordship, they were initially engaged in the settlement operation in Hubli district, Lordship.
But without the advertisement, I cannot pass an order. You
No,
can
my
take
lord-
adjournment.
My lord, kindly.
So and so learned counsel for the petitioner
My lord,
also.
kindly
heard
see
from-
page 2, my lord.
No, without the
47,
advertisement, I cannot pass orders.
My lord, for that may be given. my lord.
Eh, eh,
For that may be.
Yes. On the request to learned counsel for parties, this matter will be listed again after 2 weeks, so as to enable the petitioner's counsel to produce the advertisement. If you don't have the advertisement, you will not get any order from this court. It's not possible. We cannot fire a shot in the dark. What was the advertisement? What is the process followed? Without that, a mandamus cannot be
My
issued.
lord,
That's
from
the law.
From the same list, my lord, other petitioners were.
All right, all
already
right.
absorbed.
Next matter, please.
My lord, that may be fixed.
Date in the month of March, 15th of March.
Make legal opposition. But in this petition, we are challenging the award of the labor code and the subsequent orders passed.
So this is for disposal today.
Yes.
Then you have to wait. Other matters are there. We have kept it. Ultimately, motion. Admission is over. The motion. Motion stay vacating. Motion. There is a matter left, motion.
May it please, your lordship. This is, your lordship, this is.
The
a
matter was
proposal-
called in the morning. Nobody was there, but they wanted,
They were, I was in the division bench.
no, that's all right, but they wanted copy and time to, you got the copy.
Lordship, I've got a copy.
You are for whom?
I am for response number 14, your lordship.
You are on caveat.
Not caveat, lordship. I have instruction to appear, lordship. It's
No
a caveat.
caveat. So we couldn't.
You can't argue today.
Absolutely.
Don't open your mouth. Yes.
This is a promotion to the post of additional chief engineer for 6 posts. My lord, your lordship knows that the OM was challenged by me, the constitution validity, where your lordship issuing notice said that at the moment we won't give interim order, but subsequent orders will pass, judicial orders will be passed. Now, what has happened? On a complete
Subsequent judicial orders,
orders will be passed subject to, because my gradation list was challenged. But today, what has happened? On a wrong gradation list, which I could convince that day, they are now proceeding today with the promotion. Now resulting with what will happen, your lordship will just come to the facts. The facts are very clear. Your lordship will come to page 119. This is the provisional gradation list for the cadre of superintendent engineer. Your lordship will come to page 120. Your lordship will find that there are 4 columns, 5 columns. Your lordship will come to the 3rd column, which is important. Date of joining is SC. My client is at serial 11.
Earlier, he was at serial 2, he was brought down. At page 121, your lordship will see that he comes to the cadre on 2018. And your lordship will find that all the respondents starting from serial 2 downwards have come to the cadre in 2020, 20 and 21. So I'll straight away take your lordship to the rules on page 33. Because on that day, your lordship has made a very relevant observation that this is a matter relating to the rules. Well, the lordship will come to page 33 down below, rule 24. Gradation list. There shall be prepared and published every year a gradation list containing the names of all the members of the service. Page 33. Can I read it?
Yes.
Rule 24, gradation list. There shall be prepared and published every year a gradation list containing the names of all the members of the service cadre-wise in order of seniority and such other particulars as date of birth, date of appointment. So basically, the provisional gradation list was in direct violation of Rule 24. Immediately, I placed my representation that you must consider it. What they do, they don't wait. Then at page 125, your lordship will come to 125. Your lordship will see the date. This is the date 18, when the OM is also coming into operation. The provisional gradation list of superintendent engineer is made final. Lordship with correction. 120, lordship will find that I am brought at 17, no correction is made. Page 127, the date of entry in the cadre remains same. The rule is violated. 2018, I come to the cadre. All the other respondents come to the cadre subsequent to me. So that is the first violation. And I put in my representation, and then I challenge the constitutional validity of the OM. The clause, especially clause 4. Your lordship, today I have information that they will sit for the DPC, and resulting in total, I'll be ousted for the 6th post because I lose out. Because they are taking the plea on a similar set of facts, the coordinate bench on similar set of facts has passed an interim protection, placing one post vacant and expeditious hearing records being placed. Similar fact. I also pay. I don't want a blanket injunction. I know my limitations. So let this matter be examined, because a very important thing, I want my learned friend to apprise the court about the stand of the government, because the policy decision regarding the OM of 18 is under challenge. Well, if I may, this is a matter, same matter, Malad. He was brought down. He is a member of the civil service. And there also the rule was cadre-wide, and the matter is fixed on the 9th. Very important issues, because now this issue will affect the 60 department of the Assam government. So I want, along with this case, the OM case may also be expedited for here. I'm fully ready, and we need the stand of the state of Assam, because the rule has brought about some issues now. Because everywhere our persons are being brought down. These are the instances.
What do you mean our person?
Our members of our class, because I represented a class.
It's not a PI.
Because that day lordship had put a query. I said, because whenever Supreme Court judgments are class, reserve and general.
He's gradually fitting into that class, man. So he says, we. Pronoun is we.
Well, of course, we and I saying won't change the course of my case. So I want this.
That is a dangerous submission. You will debar yourself from taking up cases of the other class.
I take back the petitioner. Because the words are used, they are a class apart from the general. We are a class apart.
Yes, Mr. Majumdar.
That's my prayer, man.
My lord,
Only
my
thoughts.
first submission will be, your lordship will kindly see the entire petition is based on ifs and buts. His all relevant paragraphs he has said, he has learned from a reliable source. First of all, he says on 6th of February, DPC has said, some recommendations were made. DPC is yet to be constituted, my lord. This is my specific instruction. So the entire petition is based on an edifice which is just non-existent, number one. Well, on merit, I do not know what is his case. if he's saying that the gradation, final gradation is prepared is because of the OM of 18th January 2023, then the case will be one. If he says no, derogates the rules, derogates the OM of 18-1 under the rules, because of his earlier entry in the cadre, he should be senior, then it will be a different case. Which one is the case? I have not been able to understand. Lordship will kindly see the petition. He has not indicated whether he has been downgraded because of the OM or because of the violation of the rules. It's not clear. Let me complete. Yes, definitely, you get your opportunity. If his case is that he has been downgraded because of the OM of 18 January 2023, then your lordship will kindly recall, your lordship heard the matter in detail. There was a challenge to the OM of 18-1, providing for consequent catch-up theory for in respect of some of the officers, my lord, in the department, in the government. And your lordship refused. Yes. Yes. And your lordship refused to interfere with the in the interim stage with the OM of 18-1 January 2023. If that is so, my lord, if the gradation has been prepared on the basis of OM of 18-1, then there is no question of any further interference.
All right, Mr. Majumdar, two things.
Madam.
How many posts of additional chief engineer are there in the water resources department?
I'll let that one find out.
No, you will have
Three.
more instructions.
Three.
huh?
My instruction, my information is that cadet strength is 7. One is being held by,
Well, we'll find out. Just
now 6 vacancies. One is being held by Mr. Pranab Turu, where the case is pending. It's fixed on the 27th. 6
He
vacancies.
says there are 6
Yes,
vacancies.
clear vacancies.
Now, what is the zone of consideration?
1:4.
So if there are 6 vacancies, 24 will have to be considered. Correct.
He'll come in.
So his case will have to be considered. What is the criteria?
Merit, he himself has mentioned the rule.
Merit with due regard to seniority. No, it's merit with due regard to seniority
madam.
in all cadres.
Page 33, my lord. Yes. 13.
Rule 13(4).
Quote things, sir. That rule has not been quoted, my lord. Page
33.
no. It is beleg, it is seniority.
13(4). In all cadres.
13-4. 9. My lord, there are 9.
8 vacancies are.
8 vacancies.
8 vacancies are there and the zone is 1:4.
32.
So petitioner will have to be considered.
Yes.
Acha, now please tell us in page 127,
My lord.
there is a gentleman by the name of Pulak Chaudhary.
127.
His date of entry in service is 20th of June 1995.
My lord.
How he has been made senior to person who has joined on 19/6/1995?
No. Answer to more detail.
Mhm.
Is it general?
Just a minute.
This is my.
Mr. Majumdar, at 2.
At 2,
If these answers are not there, we'll
My-
suspend the entire proceeding.
my lord.
Apply.
Hmm.
May it please your lordship, matter relates to compulsion appointment, my lord. The respondent number 7, my lord, has been duly served. The lordship may kindly see the second file, my lord.
Yes.
Instruction received, Lordship, 2 weeks time, Lordship, for filing the.
What is the instruction?
As per instruction, Lordship, they stated that the SLC rejected on the ground of a lapse of 2 years, 2 years. Lapse of 2
But
years.
how the respondent number 7 has been appointed?
They fulfill the criteria of.
When was he applied? When did respondent number 7 apply?
Application dated 9/9/13. 9/9/2013, Lordship.
Hmm. And when did the petitioner submit application?
It was on 20th of July 2012.
So on what basis 9/9/13 has been accepted and 2012 application has been rejected? What is the criteria?
In the OM, Lordship, in 1615, Lordship, the principal thing stated there, Lordship. Stated that if the application eligible candidate remain pending and cannot be considered due lack of vacancies for the period of 2 years from the date of making such application will require no further consideration and must be understood to have spent their force. Then, and the petitioners was, including the petitioners was, has already crossed 2 years, 10 months and 11 days, Lordship.
But here also 2019 appointment was made.
Lordship.
So 2013 to 2019 is definitely more than 2 years. What is the answer? Huh?
Send it to SLC, Lordship, for consideration.
No. You give us, who is the officer? Let him come and explain to us. How can you do all these things?
Then,
Call him at 2 o'clock. We are not sitting here to just do routine kind of job.
Lordship, 2 days time, Lordship, for filing, 2 days time, Lordship, 2 days time.
All right, let this matter be listed again on 10. Instead of 10, you make it 13 to 2023. On the request of Mr. H. Chakraborty, Learned Government Advocate Assam, time is granted to the respondents till 9 to 2023 to file affidavit indicating as to why the application submitted by the petitioner was rejected on the ground of delay, whereas the application of the respondent number 7 with similar delay has been favorably considered. We'll call the officer to come and explain.
Item 5.
May I please, your lordship? My lord, I am appearing for my lord, senior advocate P.K. Goswami, my lord. I am filing the II, my lord, for private respondent 5 to 65. So he's on legs in my lord, court number 3. So kindly, my lord, that learned advocate general.
Then we can't take it today. This is the second call.
At 2, my lord.
No.
In my lord, 13 and 14 days.
Choose a date next week.
my lord,
Second call, we have other business fixed. It's
my
not
lord,
convenient
on
for the court.
13 and 14 is still one of the matter is going on, my lord.
All right,
We
choose a date next week.
We have some agencies, my lord.
Choose a date next week or you start arguing. This is the second call.
My
It
lord.
is not convenient for the court, tell
My lord,
them.
definitely. We
And
apologize for
what
that,
is
my lord.
convenient for the court matters the most.
My lord, definitely. My
That's
lord.
it.
My
Choose
lord.
a date next week.
Can it be on this week or next week? I'll
My
be
lord,
out
on
for
Thursday, my lord,
CP
Thursday.
matters.
Thursday,
Thursday or Friday, mo apporti na.
Thursday, my lord.
As paid for land council for both the parties, list this case again on Thursday, the 9th. We'll put it in detail as that case. Call up admission matters. Are Nana Bas BD for admission over now.
Item 6 and 7.
Yes. Where is Mr. Bidikur?
Lordship, senior is on legs in code 2, Lordship.
All right, then we'll start with the other matter, but in that case, we can't do this case today.
Yeah, not on merit, basically, or just the, that clarification is necessary to that regard. Because of the money, my senior friend will also,
Is there an IA filed by you?
yes, also can appraise.
Why is the IA? Let's see.
There are two IAs. There are two repetitions, so two IAs, my lord.
You call him, you tell him, we are taking up the IA then.
Only because of this order, my lord.
What is the IA?
My lord, in item number 6, the IA is 2834 of 2022. In item number 7, it is 2839 of 2022. And initially 2014 or interim order to be 2020.
So our prayer is same in the both the IU.
Another division.
What is the direction issued to the applicant by the All India?
In DB, my lord.
No, what is your prayer in this IA?
Prayer is just to release that, my lord.
No, please read. That is not the prayer, Mr. Baldwin.
Page, my lord, 16.
In your IA 2237 of 2019, what is the prayer?
2237 is not there. Our IA is 2839.
2839.
And 2834.
Achha, who has filed 2237?
2267 is the earlier migrant. Not us. Now present IA is 2839 and 2834.
So what is the prayer in 2834?
2834, what you will see at page
16. The authorities to Oil India Limited to release the amount of 40 lakhs as directed by the learned judicial magistrate, first class Dibrugarh. By the order dated 6/10/2015.
Achha, now where is 23/6/2015?
Page 37.
The petition.
In 2014, you cannot continue.
Last paragraph, my lord.
Bottom.
On the bottom. Having regard to the learned counsel for the parties in continuation of the order dated 9/10/14. Passed in read petition so and so, respondents are directed to credit the dues of the petitioner with the, if to which he is entitled to the new accounts of the petitioners, saving back so and so.
So the matters are to be taken up whole hog or only?
Whole, my lord, that's a different issue, whether his termination.
No,
We are not concerned about his termination. We are concerned about the direction given by the JMF.
Malad, so far the interim order is concerned, it is not the first time. Earlier also they have come for modification of this order, saying that they are entitled, the same prayer has been made, it has been rejected and that I has been.
All right, we'll finish up the entire thing. You argue.
Yes,
sir.
yes, better, my lord.
Yes.
Malad, the petitioner, who is a medical officer in the oil hospital at Duliajan at the relevant point of time. Malad, he joined Oil India on 30/10/1987.
Yes.
Then, my lord, he had a Facebook friend with a lady. He came to meet her here in Guwahati, and the wife filed an FIR against her under section, against him under section 498A, my lord. That FIR was filed on 26/2013. And in terms of that FIR, my lord, in terms of that FIR of 26/2013, I was arrested on 21/6/2013 at Guwahati. And there was news flash in the media about a doctor having an affair with a girl, with a lady being married, and all those things appeared. And now All India considered those to be nefarious activity. I will come to them. Then, my lord, I was granted bail on.
Sorry, what is it? What is the expression you use?
Nefarious.
Nefarious.
How you pronounce it, my lord? NAFERIOUS. Nefarious.
Yes.
Then, my lord, I was granted bail on 24/6/2014. My lord, since I was under detention,
Yes.
since I was detention for more than 48 hours, my lord, I was placed on suspension. That your lord.
You got bail, which date?
24/6/2013. And this FIR and this my lord, ultimately did not result into anything, because the wife said that it was out of misunderstanding. So I was granted bail and the matter ended there. Now, since I was detained for more than 48 hours in custody, the All India, my lord, they suspend me. My lord, that order your lordship will find. Your lordship will kindly take up the writ petition number 3605 of 2015.
Yes.
Now, your lordship will kindly look at Annexure 1 at page 22. The documents are chronological, my lord.
Yes.
It has been reported that you have been arrested by Duliajan police on 21/6/5, case number 148/2013 under section 498 IPC, and taken into judicial custody. View above as per clause 20.2 of Rule 20 of the All Executives Conduct, Discipline and Appeal Rule 1980, the undersigned hereby place you under suspension with effect from 21/6/2013. It is further ordered that so long this order remains in force, your headquarters shall, this is your lordship will kindly take note. It is further ordered that so long this order remains in force, your headquarters shall be Duliajan, and you shall not leave the headquarters without obtaining prior permission. Although they later on say that this prior permission has to be written, but here it is said that without prior permission of the undersigned, you will not leave the station. During this period, the suspension remains in force, you shall receive subsistence allowance and so in an undertaking in the enclosed format every month to the effect that you have not been employed in any profession, business or vocation for salary, profit, remuneration. This is the normal. Then against this order, my lord, suspension order, I filed an appeal. That appeal is at page 23.
Yes.
Then this is, I said that I was arrested. Then I was allowed to go on bail. Then paragraph 4, your lordship will find that I beg to state that my wife so-and-so in a statement recorded under 10 CFPC on 24/6/2013 by the learned magistrate has stated that she is willing to live happily with me. As such, it appears that she is no longer interested in pursuing the case. In fact, the case has not proceeded any further after recording a statement and in my release on bail. So I beg that since now this arrest and my wife has compromised, so I should be allowed to, this suspension order should be revoked. Then, my lord, during that period of time, since they are one of the allegation of is of unauthorized absent, so I submitted a leave application that your lordship will find at page 25. This is, I say, pertinent to recent legal activities. Again, I have got to go to Guwahati for legal consultation with my lawyers at Guwahati. I would be highly obliged if you grant me privilege leave and station leave permission from 6/8/2013 for a period of 10 days for the same. Then, my lord, this was head endorsement is there. Then the CBC client to leave for by the so and so, that note is there. And he said, my lord, at the bottom, that RCG committed that no executor should leave a station before 15/8/2013. Because in the next page, in the original, I could not read what is there. So I have given it dot. Now, my lord, I have been issued a show cause notice that your lordship will find at page 27. What was the allegation against me?
Yes.
Your lordship will see 2.0 and 3.0 and 4.0. The undersigned right para 3.0 of the above mentioned letter ordered that during the period of suspension, your headquarters shall be Duliajan and you should not leave the headquarters without obtaining prior written permission. Although in the suspension order it was not there, they have put a written permission now of the undersigned, which was not there in the original suspension order. However, it has been reported that on 6/8/2013, you have left station without obtaining prior written permission of the undersigned, and despite of communication to you by head medical services to report back immediately, you are yet to report back at the station till date. Your above action is tantamount to unauthorized absent from your appointed place of work and willful insubordination of a reasonable order of your superior. Thus, you have acted in a manner which is unbecoming of a public servant and thereby contravene the provisions of all executives conduct, discipline and appeal rules 1982 within bracket amended. You are hereby advised to submit your written explanation showing cause as to why the disciplinary proceeding should not be initiated against you for the aforesaid. Your explanation should reach the undersigned on or before 31/8/2013, failing which it will be presumed that you do not have any explanation to offer in your defense and the company will take further action. Then against this reply, my lord, we gave this show cause, my lord. Reply at page 28, annexure 5. I said, my lord, that on 4/8/2000, I have submitted a leave application to my superior officer, that is the head medical services, All India Limited, Duliajan, seeking leave for 10 days for the purpose of going to Guwahati for legal consultation with my lawyers at Guwahati. The head verbally replied that leave would be sanctioned. Accordingly, I proceeded to Guwahati on 6/8/2013. That, however, unfortunately, on the way when I reached Saniya and the Pulibor police station, Jorat, my vehicle bearing registration number in which I was traveling met with a serious accident. The accident could have been fatal for me, but miraculously I escaped death. That my safe vehicle was badly damaged in the accident and it has to be moved to Guwahati for repairs. However, I am yet to receive back the vehicle after going. That the aforesaid accident left me in a state of shock and delayed the consultation with my lawyers for filing a divorce petition. As a result, the process of consultation and filing of divorce petition has not yet been completed. Moreover, in the trauma of the near fatal accident, it has somehow escaped my mind to contact my superior officer. That in the circumstance, I submit that my absence from Duliajan and delay in reporting back was for bona fide reasons, and there was absolutely no intention on my part to disobey the reasonable order of my superior. As such, I request that the aforesaid absence and delay in reporting back may not be considered as an act of willful insubordination on my part, and that no disciplinary proceeding may be initiated against me. That in this connection, I am enclosing herewith once again a leave application for the period I have been absent from the headquarters. I earnestly request that the leave application may be favorably considered and leave as prayed for may kindly be granted. That I further state that I have been placed under suspension with effect from 21/6/2013, and as of now I am under suspension for more than 2 months. In the meantime, I had submitted an appeal dated 24/7/2013 under Rule 32 of the All Executive Conduct, Discipline and Appeal Rules 1982 as amended against the order of suspension and submitted the same to your good self for onward transmission to the appellate authority. However, I am yet to receive any decision on my appeal. Perhaps my appeal petition has missed your kind attention, so I humbly request that this may be looked into so that I may be relieved from the state of uncertainty which I am passing through. In the circumstances, it is my humble prayer that the explanation I have given above may be favorably considered and disciplinary proceeding, if any contemplated against me, may be dropped for the ends of justice. Then I enclose the leave application, that is at page, next page at annexure 6 at page 30, which is a reproduction almost same, my lord. And page 30, annexure 6. Then station leave application also I have given at page 32, my lord. With due respect, I wish to pray to please extend my station leave till 15/9/2013. This is due to the fact that in the last few days I have received life-threatening call messages which have mentioned that I will be shot dead. My life seems to be at stake and I'm not in the right frame of mind and I'm contemplating to take protection. Moreover, there is no formal intimation from the oil management regarding my answer to the so-called notice. This is for your information, please. Then I sent a reminder that is at page 34, my lord. This is a reminder to the email I had sent to you a few days earlier. I had come to know from reliable source that the management has not received the answer to the so-called notice sent to me, and which I replied to and sent by DTC courier to reach RC's office by 31st of August 2013. I am sending you a copy of the answer to the so-called. I do not know what the management is contemplating to do with my services, but I want to request you that nothing should be indefinite as in my case, and I want to join back. He expresses willingness to join back. However, I do not want to join back in Duliajan due to reason evident, because my lord, the wife was working in central school in Duliajan, and my lord, after those publication in the media and all, and the humiliation that followed, my lord, that's why he expresses desire that please let me join back my services in any other location beside Duliajan, Guwahati, Kolkata, Jodhpur. This will not be a problem as I am designated as OSD at the time of my suspension. Your lordship will kindly see the first time I had said that since I'm an OSD, you transfer me to any of the station. And one fact also your lordship will kindly take note. Till my date of retirement, the official accommodation was utilized by my wife only. I did not stay there. During till the date of my termination. This official accommodation was utilized by the wife only. And that also, my lord, after my termination also, she did not vacate. Then ultimately, when this matter was brought to the notice of the court, only after that she vacated the official residence, my lord. Because I said that I'm no longer stays there. Then ultimately she vacated, I think, after 6-7 months, my lord. Now your lordship will see the so-called notice at page 37.
Yes.
This is a reference to your reply dated 38/2010 in response to the so-called issued to you by the undersigned vide later dated 17/8/2013. In this regard, please be informed that your reply is not found to be acceptable. Why it is not acceptable, my lord, no reason as such has been indicated therein. With regard to the statement made in paragraph 1 of your reply under reference, we would like to reiterate that despite of head medical service informing you that he is not the authority to sanction your statutory leave permission, and only the undersigned can grant such permission, you had left the station without obtaining prior written permission of the undersigned, which was specifically mentioned in the suspension order. This was not mentioned in the written that in the suspension order. I have shown you. It has been reported that you are yet to report back at the station. Your above actions tantamount to misconduct under Oil Executives Conduct Civils and Appeal Rules 1982 amended, and the company have taken cognizance of the said. View above, you are hereby advised to report to Head Medical Services. Fourthly, now comes the, my lord.
Yes.
Your lordship may take a 5 minutes recess.
Yes. What is this termination for this?
No, there are two aspects, my lord. One is before that arrest, there were some activities. He was a radiologist. Because of those activities, he was neglecting his duties. We had to make him an OSD. And thereafter, my lord, immediately thereafter, the wife, that case came in, he was placed under arrest. Then only that part of.
What is the charge in the inquiry procedure?
Page
30, Annexure 10. The undersigned proposes to hold an inquiry against Dr. Deepak Kumar Gogoi, salary code number so-and-so under Rule 25 of the Oil Executive Conduct, Discipline and Appeal Rules 1982 amended. The substance of the imputation of misconduct in respect of which an inquiry is proposed to be held is set out in the enclosed statement of article of charge. A statement of imputation of misconduct in support of each article of charge is enclosed. A list of documents by which and a list of witnesses by whom the articles of charge are proposed to be substantiated are also enclosed. As provided under Rule 25(3) of the said rules, Dr. Deepak Kumar Gogoi, salary code number so-and-so, is directed to submit a written statement of his defense to raise the undersigned on or before 27/11/2013 and to clearly state it whether he admits or denies any or all of the articles of charge. Dr. Deepak Kumar Gogoi is informed that an inquiry will be held only in respect of those articles of charge as are not admitted by him. He should therefore specifically admit or deny each article of charge. He is further informed that if no such written statement of his defense is received on or before the date specified herein above, an inquiry will be held by the inquiring authority, which shall be nominated under Rule 25(2) of the said rules. Dr. Deepak Kumar Gogoi is also informed that if he does not appear in person before the inquiring authority or otherwise fails or refuses to comply with the provisions of Rule 25 of the Oil Executives Discipline Rules or the orders direction issued in persons of the said inquiring authority may hold the inquiry against him ex parte. Dr. Deepak Kumar Gogoi should acknowledge the receipt of the memorandum. Now your lordship will see the statement of article of charge at page 39, the next page.
Yes.
Deferred charge, madam. While posted and functioning as OSD in medical department, Oil Duliajan, Dr. Deepak Kumar Gogoi is alleged to have committed the following acts of omissions and commission, constituting serious misconduct if he failed to maintain absolute integrity, devotion to duty, and acted in the manner unbecoming of a public servant. Now your lordship will see, it was reported that Dr. Deepak Kumar Gogoi was arrested by the Duliajan police on 21/6/2013 in connection with the case number so and taken into custody for more than 48. I forgot to read one paragraph, second paragraph. It was reported that Dr. Deepak Kumar Gogoi was neglecting his official duties and engaged in some nefarious activities. Well, nefarious activities, as far as my knowledge goes, it is always used in case of organized crime. If I involve in smuggling, money laundering, and all those cases, you will see how they justify these nefarious activities, which in total disregard of the company's image and are not conducive to the position of a senior doctor. It was reported that Dr. Kumar Gogoi was arrested by Duliajan police. Then, in view of as per rule so and so, Dr. Gogoi was placed under suspension with effect from so and so, wherein it was ordered that so long the suspension order remains, his headquarters shall be Duliajan, and he shall not leave the headquarters without obtaining prior permission of the undersigned. That was reported on 6/8/2013. Dr. Gogoi left the station without obtaining prior written permission of the undersigned. And despite of communicating to him by head medical services to report back immediately, he is yet to report back at the station till date. That keeping in view his continuous absence from field headquarters without permission in spite of advice of his superiors not to do so, a so-called notice was issued to Dr. Gogoi on 17/8/2013, by which he was advised to submit his written application, showing as to why disciplinary proceedings should not be initiated against him for the aforesaid act. It was also mentioned that his explanation should reach the undersigned on or before 31/8/2013, failing which it will be presumed that he does not have any explanation to offer in his defense, and the company will take further action as deemed fit. That in response to the above mentioned so-called notice, Dr. Gogoi had to send his reply white later dated 30/8/2013. With regard to his reply, the undersigned white later had informed that his reply was not found to be acceptable and advised him to report to head medical services. However, he was not reported to head medical services till date. Thus, by the above acts of omissions and commissions, Dr. Gogoi failed to maintain absolute integrity, devotion to duty, and acted in a manner which is unbecoming of a public servant. He has acted in a manner prejudicial to the interests of the company and also disobeyed a lawful and reasonable order of his superiors and absent from appointed place of work without permission. He has also acted in a manner which is subversive of discipline or of good behavior and allegedly committed such acts which amount to criminal offense involving moral turpitude. That the above acts of Dr. Gogoi tantamount to misconduct under so-and-so, so-and-so, so-and-so. Then you also will see the statement of imputation at the next page at page 41, my lord.
Yes.
First paragraph, you also will omit. Then it was reported, second paragraph, that is reported by the then head medical services and head hospital administration, white dated so-and-so, that Dr. Gogoi was neglecting his official duties and engaged in some nefarious activity, which is in total disregard of the company's image and are not conducive to the position of a senior doctor. That the undersigned took serious note of the contention of the above mentioned letter, and the same was sent to medical health services white letter number so-and-so, where he mentioned that it is really a matter of concern for the department as well as for the organization as a whole. Radiology is one of the most important diagnostic medical section in any medical institute, and such behavior of a senior doctor dealing with radiology in particular is not at all desirable accident. Such kind of behavior may even affect his diagnostic capabilities that may lead to fatal situation. That under the above circumstances and while considering the larger interests of the whole hospital, the undersigned white the above mentioned letter suggested head medical services to assign different responsibility to Dr. Deepak Kumar Gogoi. Accordingly, Dr. Gogoi was assigned different responsibility and designated as officer on special duty with effect from 10/6/2013. That further it was reported that Dr. Gogoi OSD was arrested by Duliajan police on so-and-so in connection with case number so-and-so and taken into custody for more than 48 hours. Chief manager security so-and-so informed so-and-so, received so-and-so, so-and-so. Then next page, my lord, page 2. Yeah, head medical services informed about the incident. Then the undersigned so-and-so under suspension, the same was approved by the competent authority. Then third paragraph. Then in view of the above as per clause 22 of the so-and-so, Dr. Gogoi was placed under suspension with so-and-so, wherein it was ordered that so long the suspension orders remains in force, he shall not leave the headquarters without obtaining prior permission. Dr. Gogoi appealed to the undersigned against the order of suspension, where he was requested to revoke the suspension order. Dr. Gogoi had requested head medical services to grant him privileged leave and station leave permission for a period of 10 days. That the competent authority had not granted doctor's privileged leave and station leave, the same was informed to him by the email dated 6 and 8 2000. That is reported that on 6/8/2013, Dr. Gogoi left the station without obtaining prior written permission of the undersigned, and despite of communicated to him by head medical services to report back immediately, he is to report back at the station till date. That keeping his view from continuous absence from field headquarters without permission, in spite of his superiors not to do so, a so-called notice was issued to Dr. Gogoi dated 17/8/2000, which he was advised to submit his written application, showing as to why disciplinary proceedings should not be initiated against him for the aforesaid act. It was also mentioned that his application should raise the undersigned on or before 38/1/8/2000, failing which it will be presumed that he does not have any explanation to offer his defense, and the company will take further action as deemed fit. That in response to the above mentioned so-called notice, Dr. Gogoi had sent his reply dated 38/2013. With regard to his reply, the undersigned while later had informed him that his reply was not found to be acceptable and advised him to report to head medical services forthwith. However, he has not reported to medical services so-and-so. Dr. Gogoi, wherein Dr. Gogoi has expressed his unwillingness to join back in Duliajan, requested to join back in services in any other location other than Duliajan. Thus, by the above acts of omission as a commission, Dr. Deepak Kumar Gogoi failed to maintain absolute integrity, devotion to duty, and acted in a manner which is unbecoming of a public servant. He has acted in a manner prejudicial to the interests of the company and also disobeyed a lawful and reasonable order of his superiors and absent from appointed place of work without permission. He has also acted in a manner which is subversive of discipline or of good behavior and allegedly committed such act which amount to criminal offense involving moral turpitude. Thus, the above acts of Dr. Gogoi tantamount to misconduct under the rules and sub-rules of all of the so-and-so. Then they quote all the rules here, my lord. Then your lordship will see page 44, the conclusion. Thus, by the above acts of omissions and commission, Dr. Gogoi failed to maintain absolute integrity, devotion to duty, and acted in a manner which is unbecoming of a public servant. He has acted in a manner prejudicial to the interests of the company and also disobeyed a lawful and reasonable order of his superior and absent from appointed place of work without permission. He has also acted in a manner which is subversive of discipline or of good behavior and allegedly committed such act which amount to criminal offense involving moral turpitude. The above acts of Dr. Gogoi tantamount to misconduct and so-and-so and so-and-so. Now, list of documents were given at page 45, around 18 documents were given. Then at page 46, my lord, the list of witness which will be relied on was given here. My lord, I pause for a moment here, my lord. For 26 years, I served in oil. There was never an occasion of any misconduct or anything on my part. Just because my family and domestic life was not very congenial at home, and I had a friend in my Facebook, this personal front was taken advantage of my subordinates there because I was going to be a chief medical officer of that hospital. But if I'm ousted, then all these people who are below me, they will come to the forefront, my lord. And not only that, my lord, after this arrest, my lord, I requested the oil authorities to transfer only because all the people in that area knows me, that I have a reputation as a doctor was never, there was any blemish. My father was a renowned gynecologist of Upper Assam. My mother was a principal of a reputed college. But after that humiliation, I only requested the oil authorities that they should transfer me to some other location. So at least I can come out before the public. And then your lordship will see my reply at page 48, my statement of defense, my lord.
Yes.
In the first paragraph, my lord, I raised a grievance at page 48. This is dated 5/12/2013. First, I raised a grievance that the documents which are listed were not given to me. Then paragraph 2, your lordship, first paragraph, I denied that I requested for supply of that copies, so I would not give an effective.
So, Mr. Kwon, before that, where is the order of termination?
Yes. Page 97. madam. Annex 19.
Hmm.
Your lordship will omit the factual part because most of the factual aspects I have read it. Your lordship will go at page 99, the third paragraph. It is also quoted there in Malad, but that also your lordship. Ultimately, the conclusion is at page 101.
No, you said termination, but it's dismissal from service.
Dismissal. I'm sorry, madam, sorry. Dismissal.
So, yes.
Now your lordship will see
So
the.
what is the relief you are seeking now in this petition?
Well, your lordship will see my relief in the prayer portion, madam, at
No,
page.
you tell us. what
Yes,
is
yes,
it.
yes, yes. Yes, madam. The first relief I am sitting for setting aside and quashing of the enquiry report dated 36/2014. Number 2 is the order of 16/9/2014. Then, madam, the order of 23/1/2014.
What will
Then-
happen
then-
if
then in
69 is set aside, then what will
No,
happen?
madam, now, let me tell what the relief. Then one of the relief that I was seeking then in 2015 was to direct the respondent authority to reinstate the petitioner in service with all benefits. Allegation of nefarious activities are totally uncalled for and a highly objection, and a petitioner that the requesting the person dropping the contemplated disciplinary proceeding. Now, since madam, I have been dismissed. And now, after my dismissal, my actual date of superannuation was on 21st of July, 2021. So even if I succeed today in the repetition, I too can't be taken back in service because that is not there. Now, what I can get at this, if your lordship has that this dismissal order is bad or it doesn't stand the scrutiny of law, then at best I can be given my that period from where I was dismissed till the period of my superannuation. That period, certain benefits can be given only for my calculation of PF and those retail benefits only. That increment, I'll not get my promotion and increment, but only those notional benefits relating to my service, that retail benefits I will be entitled. Otherwise, so far, the benefits that I am entitled in 2013, they gave a letter to me, they have submitted before this honorable court also. There I was entitled to around 56 or 57 lakhs at that point of time. It's part of the record. Then I gave a proposal that, okay, when my wife also came, I did not object for my implements. Legally, in this case, my lord, with utmost respect, I don't think that your lordship will interfere, so will go into a finding of whether the domestic violence, that case is there, whether the guardianship case is there. I came before this honorable court at one instance because all my subsistence allowance were paid in the joint account. And she had so good relations with the other officers, and there's so much of sympathy by the other officers of the hospital because they consider themselves as a close-knit family. The moment it is deposited, she withdraws the entire subsistence allowance. That's why I came before this honorable court that my joint account should be changed and it should be given to my new account. Then this court said yes, that no money will be deposited into the new account. At that point of time, there was also an application filed by my wife saying that I have been given so much of money from the domestic violence case. There's a guardian children adoption case. My daughter is entitled to all those things. The court said no, nothing doing. So no prejudice will be caused to anyone. Let this money remain with the Oil Indian status quo. We will ultimately decide it, and then we'll decide what to pass orders, my lord.
So what is the present situation? Who is getting, what money are you getting?
At present, I did not get anything from my dismissal from service. What I will get is now only my provident fund and gratuity, which they have earlier submitted before the court. That only to that extent I will be entitled.
My lord, I've given a calculation, latest calculation before your lordship now.
Just a minute, Mr. Nair will hear you. What has Provident Fund got to do with Oil India? Provident Fund amount is held in trust by the PF.
No, they said that I am entitled only to the provident fund and gratuity. And as per this calculation, I think. No, city single city of there's it's part of the record. Now, as on date, they say that 87,98,358 is due to me as per this competition. Because the wife said that I am entitled to more than 1 crore. So because since nothing I could get after my dismissal from service, so I made an offer at the earliest point of time also that I have 2 sons and daughters. Unless the oil pay, from where I will pay any amount that is given. So I made an offer that half of the money, my 2 children and wife take it. And because now I have reached a certain age, so let this remaining half remain for myself. That was the offer given. But they said that no, we will not accept. We want the entire money.
Who said that?
This wife. Because in terms of the orders of the lower court. If for some reason I have violated some orders of the court, there were reasons. And for that, appropriate procedures are there. Your lordship knows I did not advise them on what procedure to follow. But so far, here is a case where I have come challenging my termination order. If I succeed in termination, getting my termination order revoked, as on that, I will get only some monetary benefits. And this observation of nefarious activities and all.
No, it is not nefarious, it is called nefarious.
Nefarious, yes. It's a very harsh word. It's normally used for crime syndicates and all, not for a doctor who has served the oil for 26 years. And that too with an allegation because I had a Facebook friend. And all these doctors, I'll show from the evidence also that they have not relied much on those personal front.
So what is the wife doing now?
She is a central school teacher at Duryazan Oil.
And what about the children?
Children are all around 26, 27 years, I think. And because I did not get this money, they also, at the initial stage, if I had given them, say, if I had got 60 lakhs also, if I had given them 30 lakhs, then they could have utilized it for their education or whatever be it. But
And the marriage has been dissolved?
No, marriage has not been dissolved.
She is still your wife?
Yes, legally she is still my wife. I said that let us give a quietus to this everything. Because from 2013-14, we are not staying as husband and wife. And because of the mistrust of both the parties and there must be omission and.
So which is the order passed by the DV court, domestic violence court?
Domestic violence has passed a order that they have annexed in there. And here it was not a question of separation because that was a completely different. Here I was only challenging my termination order. She was nowhere a party to all these things. But so that is a first question. I found that or disposal I have not any vacation of I'll show you. The domestic finance or petition fund day, happy I can file for it. Your lordship will take up IA number 2834 of 2023.
Yes.
At page 34 is down. Oh, one more thing, madam. I was also giving another offer other than this monetary, is that I have won my ancestral home at Juro, which is with my brother and sister. I have 1 floor there. And I have 1 flat in Delhi also. I also gave an offer that whatever selling price of the Delhi flat is given, we'll divide it into half also. Now, your lordship will look at the page 34, the order first. And here also, my lord, what has happened, because your lordship will see the first page, because during that time, my lord, mediation process was going on, my lord, because there was this petition, now we had made those offer, we did not contest that order, there, my lord, page 25. First page, your lordship will see page 25. First. Although we filed the Ukalatnama, because of this, all this development here in the High Court, my lord, one case after the another, my lord, the doctor did not even contested this, my lord. This is your lordship will find, judgment delivered on so and so, then learned advocate for the respondents, none appeared. Probably he could not pay the lawyers there also, he also did not appear, and because of this developments here in the.
So where is the petitioner staying now?
My lord,
Petitioner is staying where?
petitioner in, he has a house in Guwahati, sometimes he comes to here, and sometimes he stays in different places.
So he is otherwise in practice.
My lord, I will not say he is in practice because he is a mentally shattered guy. Today also I called him. He said that all these years so I did not get any money, nothing. And I wanted to give them, they are not accepting. What do I do? He is completely in a different mental state now, my lord, after all this happenings, my lord. Not the earlier guy whom I met in 2013, my lord. Now your lordship will see the order what was given, my lord, because this was an expertise order so far the final day was concerned, that is at page 34, my lord.
Yes.
In view of the above discussion, I hereby grant the following orders to the aggrieved party. The respondent is prohibited from alienating his asset. The respondent is so and so, so and so. Those assets means only the two house. One is that RG Burwa, that Nobin Nagar, which is my ancestral property, along with my other brother. The concerned authority of the employer of All India Limited is directed to release out of the amount give asset by inquiry also the sum of rupees 40 lakhs from the terminal dismissal dues payable to the respondent. The amount so and so, this all these are there, my lord. Then custody order is also there. Now, this order was also, my lord, challenged before the.
So which is the order of the learned single judge, which they are seeking vacation?
Yes, my lord. The first based on petition console.
That's in.
37.
Hey, Alaman, pen phone chala.
37 onwards.
Samut tak, এই যখন কাগজ ফাইল করেছিল, application vacate করে Your lordship will first pick up the IA number. I'm just giving it.
Yeah, just a minute, Mr. Corey, please take your seat. I'll let you know. Just
Yeah.
My lord, why this is relevant, lordship will kindly turn to the page 35, my lord.
just a minute, just a minute. Let
I'm
me-
sorry.
Single city from summer. তার ভেকেশন কাজ হয় অয়েল ভেকেশন আর কোই দিছে তার যখন দিয়ে পার কিছু পোস্ট এটা
So since 25th of January 2016, no amount has been released to either party.
Yes, madam. And this is not the first time they had filed an application for certification. There was another application also filed, madam, that is IA number 1022 of 2018.
But this order has already been held to be modified.
Yes, madam. Yes, madam. Yes. Madam, your lawsuit first take up IA number 1022 of 2018.
All right, IA will here, they are the ones in the IA, but on the main issue,
Yes, madam.
according to you, the disciplinary proceeding were not in accordance with law. Order of dismissal for service is invalid. So what is the relief you are claiming in that behalf? That's what I'm asking you.
Well, that's why on the only relief that the court can, even if your lawsuit set aside the termination order, I'll
It
be
is not order of termination, dismissal.
dismissal, sorry.
Hmm.
Even if your lawsuit set aside the order of dismissal,
Hmm.
the maximum that I will get is those financial benefits from that time till the time of my superannuation on 1/7/2021. It will be little more than, now they say 87 lakhs. It will, because of the interest and all of this amount, it will be a little more than that. Otherwise, since I am not working at that point of time, so I cannot be granted my wages and as salary. And so far,
Is it a pensionable job?
Malak, the instruction which was given on the time that order to serve, they, on the basis of the instruction, they say that they given a submission before this honorable court that it is in respect of my provident fund and gratuity, the amount of 57 lakhs and 94,000 is due. Malak, that order I'm pointing it to your lordship, Malak.
So today, according to Mr. Nair,
Yes, Malak.
the total amount your client is entitled to is 87 lakhs 98,358. So you are willing to give half that amount to your wife?
A wife and 2 children.
That's right, wife and 2 children. And
Plus, if I sell the house at Delhi, then also I'll give half the amount to them. And they have to give a quietus to everything, my lord. Because I also want my life to go on from here, my lord. And they also should.
No, but how there will be quietus? She is going to be still your wife.
Well, that's why, so both of should, I think, my lord, in the interest of both the parties, both should get a mutual divorce.
That we can't say. This is a matter of advice. What both parties should do, the court cannot advise. Anyways.
And moreover, one thing, my lord, that's my proposal. That's my moral duty towards my children and all. But legally, my lord, whether they can claim any share in my provident and gratuity, because there is a statutory bar. That is my moral obligation of my client as a counsel who can convince the client to say that you gave, at least give birth. They are your children. They are your children. You are not denying. Yes, I don't deny. Your wife is still your wife. It has not been dissolved. To that extent, my lord, that was a reasonable offer given by me to them.
And what is the other petition about?
Other writ petition, my lord, that, so, 5207, excellent, move it, note today. Just I'll refresh it once. That is in regard to that, not to credit the amount in the joint account, which the court has said that yes, it will not be credited in the joint account. I have given an alternative account number, it will be credited there. Today also, if it is credited in the joint account, it will fly at the moment it is deposited. Because during the subsistence, I did not get a single penny from that account when my subsistence allowance was deposited.
Is it a pensionable service?
Well, the submission given by Oil India Limited was that.
Is it a pensionable job?
Well, that is, they will have to clarify, my lord. But they, when the undertaking was given, sorry, where is the order to show? My lord, this, your lordship will look into the order passed on 22/5/2019 in IA number 1082 of 2015. Because it was filed by the Oil India Limited seeking clarification that which order we should follow. We should follow the order of the lower court or we should follow the order of the high court. High court order will always prevail. But even then, since they were sympathetic towards my wife, they have to, because they could not transfer the subsistence allowance. So they came with a clarification. The court said nothing doing, maintain status quo.
All right.
That order, in that order, my lord, in the order dated 22/5/2019 in IA 1082 of 2015. Malad, it was, I'll read that only one. The learned senior counsel for the applicant, that is the Oil India Limited, has submitted that as per instruction received by him, only the provident fund and gratuity amount is yet to be released to the writ petitioner, which is now in the custody of the respective provident fund and gratuity trust. That is.
So what do you have to say on this? According to him, the amount is 87 lakhs.
It is bound to increase, my lord, because that was given in, this letter was given in.
That's right. Do you accept this figure or is there any?
No, I can, because I don't have privy to the accounts, my lord. I presume that when an official says that this is due, I have to accept that it is due. I can't have access to the records, my lord. Because whatever they say is a beggar can't be chooser, my lord.
On next page also, there are some more dues, madam. He'll get some pension from the EPF fund, madam.
Yes, Mr. Nair, you are appearing for the All India.
I'm for the only, madam. My lord, with one submission, my lord, with regard to that departmental proceedings, my lord, there was a incidents happening in Senator. On 7/6, the head of the department informed the authorities about his so-called nefarious activities. It came to the notice of the authorities on 7/6. That, my lord,
What is that nefarious?
my lord, will come to page 52, my lord. This is a part of that departmental proceeding, and from here that charge was framed, my lord.
Page 52.
52, my lord.
Yes.
As has been communicated earlier, so and so taking advantage as an official tool from Surat to Guwahati did not bother to accomplish any of the assigned duties for which he was granted to. Rather, he will use that official tool for his nefarious activities. Again, he took casual leave from so and so, citing certain inescapable personal works. However, it came out later that he undertook a misadventure with an illegal lovemaking with a lady, impersonating her as his legally married wife, with whom he booked room number so and so in Hotel Natraj in Dibrugarh. Impersonating as a stranger as his legally married wife in a hotel register, needless to say, is a serious offence and is punishable under the Indian Penal Code. Further to utter shock, this incident, a relative on the part of so and so, got televised in a TV network of Guwahati, causing great damage to Oil India, hospital and medical professional as a whole. Now, my lord, the third one is, my lord, fourth one is Facebook, my lord, may go in, 5, my lord. Furthermore, of late, has been found to be neglecting his official duties. He is found to be more concerned with activities which do not have bearing on his official position. All this you will appreciate. Do not give me the right message down the lane. It should be down the lane. In nutshell, so and so activities in total disregard the committee image and are not conducive to the position of CMO radiology he is holding. All this already created substantial damage to hospital's good name in particular and to a great organization. In our considered opinion, therefore it is high time that some sort of a disciplinary action should be initiated against so and so immediately. His conduct of recent times is quite unbecoming of a senior executive of the company. You are therefore requested to intervene and do whatever is deemed fit in the matter. Now, once this was there, it was being processed on my lord.
Mr. Nair,
Lordship.
what is this? Is this does this at all? You see, who has seen him lovemaking inside the hotel room?
No, my lord, that.
Who is the
that
person
he
who
was-
has seen him doing it?
He was in the TV, my lord. It was
Uh-huh.
naturally that.
No,
act-
even if
act-
that is
act-
true,
Act
that
nobody
is at
else-
best an act of adultery.
Adultery, my lord. We only said that you being a doctor,
Hmm.
you had taken casually for this and you're going and involving yourself in such activities that causes. Now, my lord will come back to page 41, my lord. I'll just show this.
No, we have to first deal with this.
Lordship,
Somebody takes casual leaves and goes and indulges in adultery.
and that gets publicized.
The Oil India is affected by that.
My lord, the image of the organization is affected if we don't take a discipline, because my lord, the allegation is not only that,
Hmm.
because of his such activities, his work level is going down.
Hmm.
Now,
Where is the charge that is?
that's what, my lord, we come to page 41, my lord. Now,
Hmm.
41, the charge sheet, my lord.
And how is this nefarious activity? What is the meaning of
It's
nefarious?
basically, my lord, nefarious also means a immoral act which is not conducive for the society at large. That also meaning is there, my lord. Maybe they have used it, but
So the charge is on morality.
moral turpitude, maybe, my lord, but
Moral turpitude.
moral turpitude, or my lord, a moral thing which you should not have done.
No,
My
no,
lord
I'm
will-
not saying what he has done is good. All I'm saying is from a purely legalistic point of view.
My lord,
What business the Oil India have
I
to
am not
do with
on
it?
the activity, my lord. What he has done, we are not on that.
Hmm.
We are saying that because of your such activities, your work level with us is.
Where is the
My lord will
allegation that
come
it
to
was
page
because of this?
41, my lord.
Yes.
And that's 7-6 letter also it is there. Now, my lord will come to page 46.
Hmm.
My lord, second paragraph.
Yes,
41, my lord, sorry, 41, sorry, 41.
yes.
That it was reported by the then so-and-so, the so-and-so, that so-and-so was neglecting his official duties and engaged in some so-and-so, which is in total disregard of the company and not conducive to the position of a senior doctor. That the undersigned took serious note of the contents of the above mentioned letter, and the same was sent to so-and-so by letter number so-and-so, wherein he mentioned that it is really a matter of concern that the department as well as the organization as a whole. Radiology is one of the most important diagnostic medical sections in any medical institute, and such behavior of a doctor dealing with radiology in particular is not at all desirable and acceptable. Such a kind of behavior may also affect his diagnostic capabilities, which may lead to fatal situations. That under the above circumstances, while considering the larger interest of Oil Hospital, undersigned while above mentioned letter did so-and-so, service to assign different responsibility to so-and-so, Dogoy was assigned different responsibility and redesignated as officer on special duty. We had to remove him from that post with effect from so-and-so. Now, my lord, when the further action in this was being contemplated, 21-6, he gets arrested.
Hmm.
That domestic violence act.
Right.
Then, my lord, what happens?
Is that a misconduct?
No. He gets arrested, fine. We are not on that. That the criminal court will take care. We place him under suspension, saying that you will have to, your headquarters will be here. On 8-6, my lord, he leaves. In spite of being directed that you should not move till 15th, he leaves. And my lord, that station leave was never taken.
It was never even asked for.
But it was not asked for from the competent authority, my lord. It was not asked for from the competent
From
authority.
whom was it asked for?
It was asked for from the head of that, my lord. He said, my lord, it's here only.
Hmm. Asked for whom? From whom?
My lord would get it.
And what did that person do after getting
42.
it?
Well, he said, I can't give you that.
Where
My
is
lord will come to page 42, my lord.
Yes.
1, 2, 3, 4, 5. Fifth paragraph, my lord. Page 42, fifth paragraph. That Dr. Deepak Gugoi, by letter dated so-and-so, had requested head medical services to grant him privilege leave and station leave permission from 6/8/2013 for a period of 10 days.
Hmm.
That the competent authority had not granted Dr. Gogoi privilege leave and station leave. The same was informed to him by email dated 6/8/2013. that it was reported that on so and so left the station without obtaining prior written permission from the undersigned, and despite communicating to him by the elder to report back immediately, he is yet to report back at the station building.
So according to you, this is a ground for dismissal from service?
Not only this, madam, the totality.
What are the other facets?
That his working in the organization because of his activities were falling down. One. Two, this insubordination. Together, my lord, went to the imposition of the penalty of this one. Because if we don't take an action, if we permit such people to go scot-free, my lord, how do we maintain discipline in the department, my lord? And from that day onwards, my lord, I've been told, he is not very much interested with the dismissal, very much interested with the other aspect of the matter, the tussle between the husband and wife. And my lord,
That's fine.
that's between them, my lord. I have nothing. to do.
This matter in a way has spent its force, otherwise.
Because, my lord, there is no
These are
allegation
all
of,
impressions and inferences. Of course, if he has gone without, see, he was not on duty, he was suspended.
my lord,
It was
suspension
not a
also.
question of dereliction of duty. All you could have done is, you could have denied him the subsistence allowance. But dismissal from service on that ground?
It's not only on that, my lord. There are two aspects here, my lord. That's why. On that ground, maybe
What
on
is the
first-
other two? One is went and spent some private time with a lady.
the level of his working
Huh.
in the organization because of his that activities. One, because it was falling down.
Hmm.
And we have come to that conclusion that
If you start dismissing people for falling level of competence, look around and see what will be the consequence.
My lord, if that is because of some other
There is a serious
activity,
consequence every.
my lord, if that be so, let it be so, my lord, but it's a ground, my lord. That's my submission before your lordship. my
All
lord.
right,
Subject to what my lord would find.
he has not projected the case that way. If he had done it, we would have gone in that.
My lord, I understood, my lord. Because,
What happens if it is treated as an order of termination rather than dismissal?
my lord, it cannot be. It will have to be terminated. It would have to be either removal or, my lord, because he's a regular employee. my lord.
Yeah, so if it is treated as an order for removal from service,
Removal also, it will be the same effect, my lord. It
what
will
is
be
the difference between dismissal and termination?
My lord, dismissal, termination, my lord, is for a discharge, or a termination would be for a probation, my lord. Removal would
Are
be,
you sure?
I would like to project it in that manner. Termination would not come here because it's may not be one of the penalties that have been prescribed in the.
Mr. Kaur, what is the difference between termination from service and dismissal from service? Is there any difference?
Well, one will be stigmatic and the other will not be stigmatic.
No.
So for removal of service, if they put it, well, removal
Mr.
of-
Bora, what is the difference between termination and dismissal? Is there any difference?
My lord, removal will be, he can appoint, he can get a service, but dismissal will not. Termination, termination.
who will walk after All India has treated him?
He may be again reemployed.
No, termination.
And dismissal entails some more forfeiture also. One of them
Dismissal
is
dismissal
further-
and removal, both.
he cannot use this experience for any further employment.
No, removal he can, my lord.
Hmm.
Removal will not be a
Even termination. he can.
termination. Cannot. And dismissal, he cannot, he will not be even entitled to gratuity, my lord, under the Gratuity Act. And my lord asked for.
So you are willing to pay him this amount?
Anytime, my lord, because what had happened was, there was a court order from the lower court, and there was an order from my lord here that he deposit his money in a particular account. Now, we had two orders with us. We could not violate both. So we filed an IM.
All right, Mr. Bora, you are representing the wife.
Yes,
Yeah,
There is no divorce yet.
yes,
But she is the estranged wife.
yes.
Your primary grievance is about order dated 23rd of June, correct? But it appears that that order has been subsequently modified in the sense that there is a total ban of disbursement of any amount. So therefore, whether it is in the joint account or in the individual account, these orders have spent their force. So one aspect of the matter, as you have rightly pointed out, is purely question of his validity of his dismissal from service. Mr. Kumar is also saying his client is no longer interested in that. If he gets the amount which is due to him, he will be happy. Similar is the stand of Mr. Nair. So if that be so, then we don't need to go into nitty-gritties of that. The offer of Mr. Kaur is that without going into any legalities, 50% of the amount payable to him can be directly deposited to your wife's account.
Wife and children.
Wife and children, whatever. And remaining 50% should be given to him. What do you say on that? You are agreeable to that?
50% of the
All dues.
all these.
All dues, yes, yes, all dues, all dues. You are agreeable to that? Then we
My lord
finish it
will
off.
pass, we'll apportion it, my lord will.
And he will not, but this will put it quite as so far the monetary part is concerned. Divorce part will fight it in the appropriate forum, my lord.
No,
Because
quite,
when-
what quietus means, what is the
Well,
order?
today she takes 40 lakhs, more than 40 lakhs from me.
Hmm.
Tomorrow she comes with again some orders of the court and asks for more money. From where I will give it, my lord?
That's a different issue.
No, which order? How can a court pass an order?
My lord, the domestic violence order, she will show it to that I am entitled for this amount also.
That we can take care in that all
Yes.
claims under the interim orders of the High Court as well as the orders passed by the domestic violence.
And there's also a guardianship order also. In that also, all taken. No, that is also there. They also, they have claimed money. Both the petitions came before the number. So all amount, without those, I'll give that domestic, the guardianship order also. Then 40 lakhs there and 40 lakhs. Out of moral obligation, tomorrow my daughter gets married, I give her 5 lakhs for her marriage. These are all matters of moral
And
obligation.
Mr. Kaur says he also has a flat in New Delhi.
Yes, madam.
On disposal of the flat, whatever is 50% of the proceeds, that also he is willing to share with his wife
Wife
and children. In the sense that the entire amount will be divided into two parts, one portion for him, one portion for the wife and the two children, which will go in the account of the wife, correct?
Regarding that selling part, but I don't know when it will happen or we don't know.
That we need not make any.
Yes.
No.
So
Because they have obtained a restraint order in selling the flat at Delhi. That order will also have to go to shell it. And they have also obtained a restraint order for selling my ancestral property at Juror. That I'm not selling because that is with my mother's brother.
that's a different. thing.
Same as
We are
well. So
only
those-
concerned about the
those
right
orders
now,
should also
the
go.
amount which is concerned with the Oil India one.
Correct.
Because
Where
we
is
have
the,
come.
where is the order of the domestic violence procedure?
my lord, that I.
IA number?
Page number 34. man. 2834. This is the final order, my lord.
My lord, there are two orders, my lord.
Which are the two orders?
My lord, just a moment.
Page 34, monetary relief, paragraph 11. my lord.
Page 19. Page 19 is the first order in that, my lord.
34 covers everything. That's the final order.
Just a moment, my lord.
That was the interim, I think this is the final, my lord.
So it is case number 510 bracket C of 2013.
My lord, I'm giving the other case number. Just I'm giving the other orders. My lord, the other case number is mismaintenance, within bracket maintenance case number 1/2016. Which was disposed of on 6/6/2017 by the Lanet District Judge Dibrugarh.
Where is the order?
Hello. Just I'm passing it on.
And Mr. Nair, today, what is the total amount payable? Total amount.
My lord, that pension part will also have to be calculated. to
So
that.
what will be the total amount?
My lord, what I propose is, now, today I don't have the other part. 87 lakhs is true that I got it. This, how much it will turn out to be, the second page, the calculation. how much it-
We have trust
No,
on
no,
her, we
no,
have
no.
to do it.
My lord,
Don't
what-
keep it
my lord,
pending.
What I propose is, my lord, if your lordship can direct us, my lord will give us a month's time to do it. What we do is, we will calculate all his dues, whatever dues is due to him, and thereafter we'll communicate that both to both the parties. And thereafter, my lord, we will apportion the amount. Whatever dues are, there will be, my lord, a pension, which he will get monthly.
And what about the amount which you have withheld? There is some interest accrual on that.
With interest, my lord, it has come to 87.
On 14th,
51.
on
something.
14th, give us the figure. That
14.
order will be passed.
Lordship, I'll give the total figure.
On 14th, we'll
Or
pass the order.
I'll
and say-
ask them to do, my lord, I'll ask them to make the full calculation,
Yes.
whatever is due, and then place it before.
Yeah.
Fine, my lord.
Can you please circulate to both sides?
I'll do that, my lord.
So
I'll
the
do that.
order we
Yes.
propose to pass is that this total amount,
Lordship,
which will record that he is accepting, will be divided into two parts.
lordship,
One part, which is one half,
lordship,
which will be deposited in his private bank account,
lordship,
personal account.
whatever account they
The
give.
second part will go on the head of the wife, that is respondent number 7, and for the benefit of the two children. But the money will be deposited in the account of the wife. So this will finally put at rest
Lordship,
all claims arising out of these writ petitions,
Domestic
domestic
violence and the
violence
maintenance case.
order, as well as the maintenance case.
lordship, yes.
If there is any further dispute,
That-
that the parties will be entitled to seek legal remedy.
Yes.
That's the order.
Lordship, that much.
I'm dictating the order today, but
Lordship.
I'll sign it.
14, after the, after
All
the.
right,
Lordship.
you take down.
That would be the best Valentine gift to my estranged.
No, I know that. I know that. I know that. You'll love it. That is the reason we have put it on 14.
14.
If there was another council, the date would be different. We have heard Mr. B.D. Court, there is senior council assisted by Mr. Sir. So it's appearing for the order of date would be 14th, huh? I'm just dictating it today so that
14 to begin.
also heard Mr. U.K. Nair, managed senior council assisted by Mr. K. Kalita.
K. Kolitam.
K. Kalita. Learned council appearing for the respond numbers 1 to 6. It is in item WPC 3605 of 2015. I have also heard Mr. Anshuman Bora, learned senior council hosted by Mr. J. Patwari, learned council appearing for the respond number 7. Full stop. In this writ petition, the petitioner has primarily assailed the disciplinary proceeding initiated against him by the memorandum of charge dated 5/12/2013, as well as the consequential order of dismissal from service issued on 16th September 2014. First up. Yes, the petitioner was serving as a doctor under the respondent number 1, that is Oil India Limited, and posted at Duliajan. First up, during that time, some incidents occurred in his personal life, which had led his wife to file a criminal complaint, which was registered under section 498A of the IPC. Full stop. The petitioner was also arrested on 21/6/2013, lodged a FIR on 26/2013. Which was registered under section 498A of the IPC. The petitioner was arrested on 21/6/2013, but subsequently released on bail granted by the court on 24/6/2013. Full stop. However, 2013. Full stop. However, in view of the fact that the petitioner had spent more than 48 hours in police custody, he was placed under suspension by order dated 27/6/2013. Full stop. During the period of his suspension, the petitioner was instructed not to leave the headquarters without obtaining the permission of the authorities. However, due to the circumstances mentioned in the writ petition, the petitioner had to come to Guwahati on 5/6, is it 5/6?
Yes.
On 5/6/2013, after submitting an application for station leave, which however was rejected by the competent authorities by order dated 6/6/2013. Date is correct, no? 5/6 and 6/6?
My lord, 5/8/2013. Page number, my lord, 26, my lord.
5/8/2013, which was rejected on 6/8/2013. Full stop. Taking note of such fact situation, the authorities had initiated a disciplinary inquiry against the petitioner and ultimately found him guilty of misconduct. Consequently, the major penalty of dismissal from service was imposed upon him, full stop. The petitioner was also not paid his subsistence allowance and other dues payable by the oil.
It was paid in the joint account, the subsistence allowance and the wife.
Due to some dispute arising between the petitioner and his estranged wife, namely the respondent number 7, regarding the account in which the subsistence allowance was to be deposited. It appears that due to different orders passed by the court, no amount was paid to the petitioner since 25/1/2016 till today, full stop. Mr. Kaur, learned senior counsel for the petitioner, submits that although his client is aggrieved by the order of dismissal from service as well as the manner in which the disciplinary proceeding was conducted, yet considering the age of the petitioner and the fact that he has relocated in Guwahati, his client is not seriously pursuing the challenge against the order. At this stage, the only live issue in this writ petition is pertaining to the amounts receivable by the petitioner from the company, bracket OIL, full stop. Therefore, if an order is passed by this court directing the respondent authorities to pay the dues of the petitioner, then he would be willing to part with half the total amount to be enjoyed by the respondent number 7, that is his wife and the 2 children, full stop. Responding to the above, Mr. UK Nair, learned senior counsel, appearing for the respondent numbers 1 to 6, submits that the total amount payable to the petitioner, including the area of subsistence allowance.
No, that is not there. Only now provident fund and gratuity.
Total amount payable to the petitioner, along including provident fund, gratuity, and area. He says some pension also he mentioned.
Yes.
Huh?
He will get the contribution towards EPS, EPS 95. Next page.
All right, EPS contribution, then
Only that.
where is that document gone? Where is the document gone? There was a statement, it is gone now. Can you give it to me once? What are the accounts? EPS contribution?
EPS contribution and PF amount, lordship. PF amount towards total amount 87,98,358, lordship. And EPS, he will get around 40,000 monthly, lordship. 40 or 41,000 monthly.
EPS contribution and gratuity.
PF.
PF and gratuity
Yes.
would comes to such and such, put the figure blank. And if the petitioner accepts the said amount, then the same would be released in the account of the beneficiary as directed by the court. At this stage, Mr. Kaur submits that his client is accepting the amount projected by the Oil India as the total amount payable to
Along with
the
that
petitioner.
Delhi flat and that restraint order.
Full stop, full stop. At this stage, Mr. Bora submits that if half of the total dues payable to the petitioner is deposited in the bank account of the respondent number 7, then she will be agreeable to the said proposition, full stop. Taking note of the submissions made by learned counsel for both the parties and as agreed to by them, this writ petition is therefore being disposed of by providing that out of the total amount, out of the sum of rupees so and so, which is the total amount, 50% of the same being rupees so and so, shall be deposited in the personal saving account of the writ petitioner in the HDFC Bank, is it? HDFC Bank.
HDFC Bank. I'll give the account number.
HDFC Bank account number so and so at, this is Duliajan, in the Duliajan branch, full stop. Remaining the balance 50%.
Well, I'll give the account number during recess. If
Balance
it is not
50%.
Duliajan also, I'll give an account number.
Balance 50% will be deposited in the account of the respondent number 7, namely so and so, to be enjoyed by herself and the 2 children and their 2 children. Full stop. This arrangement will put at rest all claims arising by and between the petitioner and the respondents arising out of this writ petition and the other connected proceedings, including the order dated, including the final order dated final order 6/10/2015 passed by the learned judicial magistrate first class, Dibrugarh, Assam in case number 510 bracket C, capital C, bracket close oblique 2013.
And
as well as the-
mismaintenance case number 1 of 2018.
as well as the orders passed by
16.
the court as well as the order dated 6/6/2017 passed in Miss bracket maintenance bracket close case number 1/2016 full stop. Insofar as
Well, passed by the district judge Dibrugarh.
passed by the learned district judge Dibrugarh, full stop. Insofar as any other claim, public counterclaim by and between the parties, that is the writ petitioner and the respondent number 7, it will be open for either party to seek redressal.
Well, that restraint order in disposing of the flat in Delhi that they have obtained that because of dispendency of this domestic violence, that may kindly be lifted.
Where is that order?
Well, they have taken it subsequently, my lord.
No, where is the restraint order?
That is. That they have, that order is not
That
here.
order is not before us. We can't pass any order.
6/10/2015 order.
Seek
I think
redress.
it is there in the 6/10/2015. It is
Seek
no, my lord, it is
redress
there in
under the
6/10.
law.
The 6/10 order, so.
By filing appropriate proceeding. That's it. The writ petition stands disposed of.
My lord, that restraint order in.
Restraint order will not change
No,
it.
it's in the main order of the
No,
domestic
even
violence.
that will not change it. That will be open for the, you file a joint application
Yes,
to get it modified.
yes, but that option your lordship will give it.
That liberty has been given.
To file joint application. My lord.
And other proceedings stand disposed of in the light of the order dated so and so part by this court. All right, all other, yes.
My lord, Lordship has mentioned that 50% of the overall amount
Hmm.
be deposited to his personal bank account.
Hmm.
The same already mentioned my personal bank account.
You give the bank account number, etc.
Yes, I'll-
Give it to, the balance 50% will be deposited in the personal bank account number or bank account bearing number so and so of the respondent number 7 to be enjoyed by herself and the 2 children.
My lord, my lord, this is in regard to the total. My monthly pension, my lord, again, they will ask half, my lord. That is also a problem now.
Because
Monthly
monthly pension, lordship, he has to deposit the all the submit all the documents. lordship.
Yes, that
He
they
has
will
to
have no
all-
claim. Monthly pension, I will get hardly
40,000.
some 1,000 rupees, man.
Let him enjoy his monthly.
Yes, my lord, that
So,
your
lordship
lordship.
may-
Add one line 50/50, you say remaining
From the
50.
PF.
if the petitioner is entitled to any monthly pension, it will be open for him to file appropriate application.
No, no, I'll submit the documents to All India. and
It
will
it
be
will be open for the petitioner to submit necessary documents to the authorities for processing his claim. First of, it is made clear that the respondent number 7 shall not have any claim on the monthly pension receivable by the petitioner.
And all will do it this monthly pension within a time frame, otherwise they will keep
Okay,
it pending
first
because of.
he has to submit.
No,
the
I'll
documents.
deposit that
You do it, you do it.
forfeit or.
Yes, yes.
Development.
But this order will be signed on 14th.
Yes, sir.
They will give the document.
Huh?
They will give
Yeah,
the
we
amount.
will. Yes.
No, we give data.
In fact, both of you, but don't disturb the court, saying that I don't want this line, I will
No, no,
not.
I've finished.
On
I have-
14th, you will circulate the order, both of you look at it. I will not change the order unless
sir.
there is a
Yes,
mistake
sir,
in
because
there.
this is a.
This is the order I'll pass, but I don't want to spend another half an hour that day.
Yes, sir.
That's why this order has been dictated. So only the figure will come and the order will be passed. That's all, yes?
Yes, sir.
At 2 then. Okay,
Declare.
Mr. Kaur?
Met with the Jala. And the seniority is to be determined on the basis of his merit position in the APSC list. In the APSC list, I am above him. He is, Pulak Chaudhary is above. List is before us. Take my phone.
And this gradation list has been prepared pursuant to what principle?
Well, this is the criterion, this is the principle. Yes, from the date of his initial appointment. And because of his,
Yes,
since he belongs to the reserve category, my lord, he got the promotion early and we caught up subsequently. And my lord, by virtue of this OM of 2002, that is consequential seniority, if he had stolen a march over the general category, because of the OM of 18-1, which your lordship did not interfere at the interim stage. Now he has been downgraded, it is pursuant to that.
yes.
I appear for respondents number 14 and 21. We have already filed our power. As well, kindly give me 10 minutes time. I'll explain the.
No, he has not yet presented his case.
I thought you've done it. Sorry. Lord, from the submission of the learned additional advocate general, he did not answer the query which I have put before this court in terms of the petition. My lord, my contention was very limited, that the gradation list is supposed to be made in terms of Rule 24, cadre wise. The column which is given below, there is a 5th column coming. This has happened first time. The lordship will come to page 126. The 5th column talks about an APSC notification recommendation, means well, apparently they were senior to me in the initial stage because I got accelerated promotion. After 25 to 26 years, this issue was settled because there was no challenge from their side. The APSC list is given for the simple reason to bring in the redundant catch-up principle. Because the learned additional advocate general has not been able to show that why the gradation list was not made cadre-wise. That is my simple question. Because if it is issued cadre-wise, naturally I have to be above them. Because lordship, I came to the cadre earlier. And as regards the submission, that the qualifying service, the merit list of the APSC, if that is the reckoning, if that is the benchmark, why a lordship will come to rule 12 promotion, rule 12 clause 3. And that part they have to answer. If I may read that part. Rule 12 promotion, how it happens, because when promotion happens, you need to qualify service in particular cadre. Suppose you are an assistant engineer, you need to complete 5 years to go to the assistant executive. And from the assistant executive, you go to executive and onwards, there is a qualifying service. The rules is very specific that you have to comply with it. Now, if this gradation list is to be accepted, you bring in a new criteria, that is APSC list,
which is not, is unheard of in the rules. Basically, are you saying that as you go up the cadre, you need to have that APSC's qualifying period? Then what is the purpose of having Rule 12.3? Because the Rule 12.3 says that you qualify and you go up. 5 years is the benchmark. Here, if this is accepted, the fifth column, last column, the vice is at the fifth column, because what they want to do by bringing the fifth column, they want to revive the catch-up principle, because the 18 OM talks about the catch-up principle, which was which was not considered by the learned single judge, because the catch-up principle is already nullified by the 85th Amendment. There is no dispute. In fact, the learned counsel for the other side will also say that 85th Amendment has nullified it, because Ajit Singh 1 and 2 were giving the benefit of catch-up. And the parliament was put representation that if catch-up comes in, the reserve will never come up. So the 77 Amendment was brought in to give the benefit of accelerated promotion, and the 85th Amendment was brought in to give the benefit of consequential seniority. 77 and 85th Amendment joins, and that benefit is given so that you go up the ladder. And the law is, as you go up the ladder, higher post, you will have to compete with the general on merit, RK Sabharwal. Now here, first of all, the department has not been able to explain till now why I was brought down, why Rule 24 was not followed. Because if Rule 24 is followed, the case is very simple. Let them prepare a fresh gradation list in terms of Rule 24 cadre-wise. Because if the cadre-wise is brought in, not brought in, they can bring in collaterally the catch-up principle. That is my case. So what I feel that the government has not been able to explain my simple question regarding violation of the Rule 24. The fact that I came to the cadre earlier than all the respondents, naturally the gradation list which was finalized has to go, and any selection.
Mr. Das, just a minute. You think persons who are junior to you have been given higher position in the gradation list?
In terms of the final gradation.
Let's take the case of one of them.
Yes.
Who is it? Respond number 10.
Yes.
Achha. How is respond number 10 junior to you?
No, Malay.
How is
My
respond-
case is, the respondent number 10's case is not my case. My case is I'm sticking to my point. The Rule 24.
Your
is-
point will be different, Mr. Das.
Yes.
We are asking you
Yes.
that you are aggrieved by the gradation list,
Yes,
correct?
which was not done in violation of the rules. That's my
But
case.
that's the facts have to say.
Yes, the facts.
So who, according to you, which of the person in this list are junior to you, but they have been given a higher position? in the-
Basically.
Let's take the case of one of them.
Yes. Let respondent number 1, Praveen Bhuyan.
Respond number 1.
Sorry, the officer, serial number 1, sorry. The officer at serial number 1.
All right, according to you, he is junior to you or
He
should-
is in the cadre, he is definitely junior to me
All
because.
right, so let
date
us-
of cadre- yes.
Let us see how it is.
Yes, yes,
Please substantiate that.
yes. So he.
How is a junior? Please
He's,
substantiate.
because ultimately seniority, the rules are very specific. The seniority talks about Rule 21, 22. Lordship, I am coming to the rules.
No, Mr.
Yes,
Das, please-
Rule
please-
22.
Please demonstrate how is he?
Yes, for demonstrating, I need to go to the rules.
Correct.
Rule 22, your lordship will come. The seniority of a member in a cadre appointed by direct recruitment or by promotion shall be determined according to the merit, order of merit in the respective select list. The respective select list actually talks about the list made in each cadre. It cannot envisage that the respective select list will mean the APSC selection which was done 30 years back. So that is my first case, that the respective select list is the cadre, because this word starts with the seniority of a member in the cadre appointed by direct recruitment or by promotion. In my case, it is promotion. Shall be determined according to the order of merit in the respective select list, because for each cadre, separate select lists are made. So it is absolutely unimaginable to conceive that the respective select list will mean the entry APSC's list, which finds reference in column 6. That is the date of joining of all officers, because naturally there's no dispute. They came earlier to me. I stole a march because of the benefit given to me under the 16(4)(a). And after 25 years, all of a sudden a rule, an OM is made where I have been, my entire benefit given is gone.
So
And-
this position has been reversed because of the OM.
Yes, and that is my case, that the OM could not have brought the catch-up principle because the
Correct.
catch-up was
So
nullified.
so
That is
if
my-
the OM is maintained, then this position cannot be disturbed.
Malan?
If the OM is not set aside by the court,
No, my OM will be an additional point. My case hinges on the rules, violation of the rules. Because my learned friend rightly said, Mr. Das has to specify where he stands. I don't go into OM now. OM is a defense I'll take on later when the constitutional validity case comes up. Now I am sufficient firepower to go to the rules. The rules are violated in my case. That is my case. The cadre-wise, if you do, I get my seniority. You apply the catch-up principle to downgrade me, and then you hold a selection. So that is my case.
so but in any case, you will now be considered for the.
No,
promotion.
Malak, I will now be considered, but they have not been able to show as to why I was brought down, because the first order.
That
of
we will
lordship-
say, right now,
Yes.
that cannot be
No,
decided.
no.
today.
So what I pray, since similar matter, one post may be kept vacant and they may go with the proposal.
We'll ask them to consider your case also.
Yes.
And
But what about if lordship allows them to consider case, then it will be dehouse the rules because they have already brought me down.
that will be an interim order.
No, but after I come down, what is the point of their consideration? I have already lost. That part they have not answered. They answered with a argument which is not tenable. I could show that the APSC list never comes in. They brought this deliberately to bring in the catch-up principle. Because they know under the rules, they cannot bring me down. They can bring me down only through catch-up principle. And catch-up principle is impermissible. So what I personally feel, I'm not asking for a blanket stay. I want that one post be kept and the matter be expeditiously heard. That definitely I can vouch for. That is my. Because what happens in the final disposal, suppose the post which is kept, if I can show that a violation of the rules is there, then I need not go to the catch-up principle. On the rule itself, the fresh gradation will be made in terms of the rules.
That's all right,
That
that's
is
all
my
right.
case.
We can also provide that any promotion given will be subject to.
No, that order is already there. I have come for the second time because that order, their view is that order is not important. We will hold it because we have downgraded you. That is the reason I come for the second time. And I think this is a phase where lordship will protect me with, because your lordship has given many orders on that, keeping a post. That's a legitimate prayer.
No, but if it is kept vacant, how
Yes.
do you
No,
stand to
kept
gain?
vacant, Malad, your lordship has kept vacant because I am under judicial review. Because your lordship has already passed an order subject to. They are defying that because your lordship, when your lordship passed the order, your lordship was convinced that there was violation of the rules. Today I could show that the violation is there, they are holding today. And I get whether the subject matter won't help me, provisional, because I lose my seniority. That has not been explained. And in fact, that dispute of seniority will remain because if they consider me on the ground that zone of consider, I will not accept that contention because already I have lost, because I have already come down.
So Mr. Das, subject to what they say,
Your lordship can always mold the-
we must, I must make it very clear to you that if an interim order gives the benefit to the petitioner, then this court is open to granting such interim order. But if the interim order is only for an ego or any other
No, no, it
purpose.
is not an ego.
No,
but-
please listen,
Yes.
please listen. If one post is kept vacant, it may so happen that if you lose in the writ petition, then that phase, the public will be deprived of the service of and the department will be deprived of a service of an additional chief engineer. If you succeed, then the authorities will have to consider you afresh.
Yes.
There cannot be an
But,
order to.
what about my lease, my
listen.
enforceable right? I have come to this.
Please listen.
Yes.
It will help you.
Yes, yes.
Your enforceable right is only to be considered for promotion under the correct parameters.
Yes.
So if it is held that your downgrading was dehorsed the rules, if the declaration is made by the court, then the court can always give an order that now you correct the seniority list as per this criteria and then consider his case for promotion to the post of so and so. Therefore, if an order is passed that any promotion will be subject to outcome, that means the moment you succeed, the post is always available for you. But if there is a stay on filling up a
No,
particular,
I'm not asking for a stay.
if
What I want, then Lordship can give one relief. I'm ready in next week if the matter is heard fully. For that period, I'm ready.
today we'll hear it.
Yes.
Final argument, yes.
Yes,
Yes, argument.
Then we can start it on. Then your Lordship will have to, because it is tagged up with 366 also. Because there I challenge the gradation list. Unless you-
366 is listed today.
No, it's not listed because that is the first when I doubted that I'm going down.
Hmm.
And today is the phase where they are going to hold the promotion. So that 366 has to come because I made an environment, two has to join because when I make my submission, it will be the two WPCs will have to be there because it's connected.
You want it day after tomorrow, both of them together?
Yes, we are ready for the
My
final.
lord, with all respect, can I make one submission, my lord? This is not such a matter. which
No,
calls-
we have been hinting at him.
No,
Mr.
no,
Das
my
is
lord,
not
it is not
accepting.
such a matter that it cannot brook some delay. My lord, this is not a matter where lordship should extend any, urgency. There's not, but will kindly give me 10 minutes time. I'll say why my learned friend is wrong. Give me 10 minutes time. But on merit, assuming my lord, what has been done by the department is complete. I'll satisfy your lordship, it is absolutely correct. My learned friend is saying this seniorities should be fixed according to rules. My lord, the general candidates have been saying for the last 2 decades, which he was opposing all throughout. All of a sudden, my lord, he has become wiser. Now, my lord, what is the case? Please come to the rules. We're concerned with seniority. Now, rules provides how a seniority will be determined. But my lord will kindly have this. I continue. I'll just place 2-3 rules, then one judgment, then I'll wind up into. My learned friend says, as per rule 24, gradation wise seniority list has to be maintained. And rule 22 says how seniority is to be maintained. My lord will first come to rule 12, sub rule 2 at page 1325. Subject to suitability, my lord. Subject to suitability as may be decided by the board and by the appointing authority as set forth in rule 13. And also subject to possessing such qualification and experience as may be prescribed by the governor from time to time, a member shall be eligible for promotion to the corresponding higher grade in the manner hereinafter provided. Now we are concerned with, my lord, from Roman 4 superintending engineer to additional chief engineer. So this is the procedure. From then, my lord will kindly come to rule 13, sub rule 5. In order, lordship knows, in order to become a member of a cadre or a service, one has to enter the service in accordance with rules. Rules means the recruitment rules, not the roster rules. Now please come to sub rule 5 of rule 13. The board, after examination of the documents and information, board means that selection board, after examination of the documents and information furnished by the appointing authority, shall recommend to the appointing authority a list of officers about double the probable number of vacancies. Now kindly mark the last 2 words. In order of preference, found suitable for promotion. Let my learned friend show that his client was ever found suitable for promotion, qua general category candidate and all candidates in the zone of consideration. My lord, they earned a promotion by virtue of roster. They never earned promotion by virtue of this rule. I'm reading it once again, my lord. A board, after examination of the documents and information furnished by the appointing authority, shall recommend to the appointing authority a list of officers about double the probable number of vacancies in order of preference and found suitable for promotion. My lord, the rule mandates a member of a class or a cadre, in order to be eligible for promotion, it is given in rule 12.5.4, which I've read. And to earn a promotion, my lord, the selection board must found in suitable amongst the candidates in the zone of consideration minus reservation. Now, my lord, reservation is a special law in terms of which their merits were never assessed. Merely because that particular point was reserved for a particular community, merely because they were in the zone of consideration, my lord, they were picked up and put in that slot. Now, my lord, what I am saying is has been supported by the Supreme Court. One paragraph from Ajit Singh, one, my lord. Please come to this Ajit Singh, my lord. So they were never, my lord, found suitable. They earned promotion because of the roster. Please come to para 9, my lord. At page 729. Once the quota is full and roster has stopped for the members of the scheduled caste and backward classes in respect of whom reservation has been made and roster has been prescribed, then their case for promotion to a still higher grade against a general category post has to be considered, not treating them as members of the scheduled caste or scheduled tribe on any crux. They cannot be promoted only on the basis of their accelerated seniority against a general category post. In R.K. Sabharwal, it was said that candidates belonging to scheduled caste who compete on their own merit along with the general category candidate, then they are not to be counted with the percentage of reservation made for such candidates in service because they have competed with the general category candidates on their own merit. This is the exception, this is not the case here. Because of the roster, my lord, they got promoted. The same principle which has been enunciated by Constitution bench in the aforesaid case shall be applicable whenever a member of a scheduled caste or backward class has got accelerated promotion to a higher grade and is to be considered for further promotion to a still higher grade against the general category post. The accelerated promotions are to be made only against posts reserved or roster prescribed. There is no question of that benefit being available when a member of scheduled caste or backward class claims promotion against general category post in the higher category. It need hardly be pointed out that such a candidate who are members of scheduled caste or backward and have got promotion on the basis of reservation and application of roster before their senior in the lower grade belonging to the general category in this process have not superseded them. Merely because they have earned a roster promotion, therefore they have not superseded the general category candidates. Now my learned friend is speaking of rules. Now if we are speak of rule, then as per the rules, we are not promoted. So you have not superseded me. Because there was no inter se comparison of merit between them. As such, when such seniors who belong to general category are promoted later, it cannot be said that they have been superseded by such member of scheduled caste or backward classes who have been promoted earlier. While considering them for further promotion against general category post, if only fact that they have been promoted earlier being member of scheduled caste or backward class is taken into consideration, then it shall violate equality clause and be against the views expressed not only in R.K. Sabharwal, but also by 9 judges bench in Indra Swamy. When a reserved category candidate earns a roster promotion, my lord, his suitability is not judged qua other candidates.
That I have noted, yes, sir.
Therefore, my humble submission is, my lord, when you are talking of rules, if you want that in every grade, your seniority is to be counted, then you must earn a promotion according to rules. You have not earned your promotion under this rule. You have earned the promotion under Article 16(4)(a), which gives you accelerated promotion. That you have got. So where is the question?
The law is now settled that accelerated promotion will not give accelerated seniority.
Senior.
That part is
That
settled.
part is senior. And for a moment, it is not our case that in Assam, reservation in promotion is not that it is there. And even accelerated seniority, consequential seniority is available to class B also. In case of A, government of Assam has, now my learned friend repeatedly makes one submission, my lord, that catch-up principle has been done away with by the Constitution Amendment. No, it has not been done away with. It's an enabling provision. It is for a particular state, whether to give, my lord, accelerated promotion and consequential seniority. The state may decide will not give. Nobody can come to the court and pray for a mandamus. I belong
So
to,
under the OM of 18th January, the
Yes.
state has now decided not to give accelerated seniority.
in fact, my act also, my lord, even the act when it was amended in 2012, then also same position was maintained. The same position was maintained on 29/12/2014 and 3/8/2016. It is only because of the judgment of the learned single judge, my lord, this complicacy arose. Now that has been also set at rest. Now, therefore, my lord, when you are talking of fixation of seniority, then you must born in that particular cadre by prescription of the rules, which we have not.
So all these persons who are above the petitioner,
Are all senior to them, my
senior in terms of,
yes, by virtue of roster in every gate. For example, my lord, I'll just give an example. The petitioner, my lord, he entered service in 95. I am appearing for my lord, respondent number 14 and 21. Now, my lord, I think one example of respondent 23 was taken. Huh? Now, in that example, what I find, my lord, he became assistant engineer in 95 and respondent number 23 also 95. Now, by virtue of roster, he became assistant executive engineer in 2005 and the general category candidate catch up him in 2007. That means respondent number 23. Similarly, executive engineer, he became in 2015 and respondent number 23 became 2016. Now, as far as SE is concerned, he became in 2018 and SE he became 22. Now he says, since I became superintending engineer in 2018, therefore my seniority should be fixed above him. That is his case. How is it possible? Which court of the country will give you? Are you not aware? Is it so unintelligible? The judgments of the Supreme Court, the provision of the law? Only one argument. Everything has been settled by constitutional amendment. That constitutional amendment has been understood in Magna Gras by the Supreme Court in a particular manner. The manner is, it is an enabling provision. It is for the state whether to give that benefit or not to give the benefit. If a particular state or union government decides to not give, end of the matter. Now, therefore, my lord, now supposing, my lord, today instead of making a seniority list as of SC, if a seniority list is prepared in respect of every grade, the same position will continue. It's not a question of reviving a 25-year-old seniority.
so why is he saying it has not been prepared?
No, what he's
grade-wise?
saying is, my lord, what he's saying is, simple words, what he's saying is, he became SC in 2018. We became SC in 22. This respondent of 23. Therefore, he says he should be senior. He became member of a cadre of SC earlier than the general category. Now, he has already forgotten that when you became SC, you were not found to be suitable by the selection board. You were promoted because you belong to a particular category against whom a roster is, predetermined. That was not a promotion where the merit of the petitioner was judged who are the other candidates. That's what Supreme Court says, well, it's not me. So now what is the wrong, my lord?
So until and unless the OM is set aside.
Yes. My lord, there, in any case, my lord, what is the prejudice he will suffer? I am told, my lord, there are 9, cadre strength of additional chief engineer is 9. Presently, only one additional chief engineer, that of a reserve category, is holding the office. 8 are vacant. So possibly, my lord, government will undertake an exercise for filling up all the 8 vacancies. Now, he is at number 17. Even if 5 posts are filled up, my lord, he is within the zone of consideration. So at this stage, he cannot have any grievance because ultimately, my lord, the selection will be made on the basis of merit, not merit with due regard to seniority. Please have a look.
No, where is the criteria?
Yes. My lord, at page 1327, on top, small d,
Yes.
all other promotion to the rank of superintending engineer and above on merit only. So what is the prejudice he suffer? My lord, lordship will not pass an interim order merely because somebody is asking for an interim order. If there was a requirement of protecting his imminent violation of right, then yes. Now, you are within the zone of consideration. If you have got higher merit, you will catch up. The problem earlier was you never had the merit, but because of this roster accelerated seniority, you used to be in the zone of consideration.
So now there are 8 posts of additional chief engineer.
There should be in the zone 32. He's in 17.
No, but what if they start doing it in a piecemeal manner? Say two at a time, two at a time.
No, I think that's not the,
We'll ask them.
that's not the, I think, anyway, that my learned friend will clarify.
How many,
No,
yes,
for
just
example,
1 second. Mr. Majumdar, how many posts are there? So you will have to take the exercise for all the 8 posts,
yes,
obviously, because otherwise,
but there are no.
if all the 8
eligible
posts are taken into consideration and it is 1:4, then he comes within the zone and the criteria.
Even
is
for
met.
the 8 post, man. Even if 5 posts are advertised also, then he is in the zone. Not to speak of 8 minor, even if 5 is considered, he is within the zone because he is 17. If it is 5, then 20 will come. So, my lord, what right? My lord, 226 petitions are filed for enforcement of a right. What is his right? Right to be considered for promotion, which in any case will be considered. Lordship will not allow him to create a right. He must have a right. Which right will come for enforcement? Yes, he has a right of consideration. That Lordship will ensure. That I cannot say no. So, my lord, in the facts of this case, I don't think, my lord, any case has been made out for an interim order. My lord, let us not, go by this argument that Article 16(4) has done away with catch-up principle. No, that's not the law, my lord. Even today, Supreme Court is saying when there is no consequential seniority, catch-up principle automatically revives. That's my humble submission.
Well, 3 arguments were advanced. The first arguments I'd like to clarify, the rules are very specific. Rules, selection of promotion shall be on the basis of merit with due regard to seniority in all cadres or posts. So seniority cannot be ignored. It is not merit. That is the basis of my case. So the rules are very specific. The other submission which was made was that as per Ajit Singh, he had made some submission. My lord, the Ajit Singh is already overruled. And Article 16(4) giving the benefit of accelerated promotion and consequential seniority has been upheld in Nagraj. So my learned friend need not reopen that because that's a settled position. Any number of submission won't revive it. It's gone because the constituent power of the parliament has been exercised and that catch-up principle is gone. The third argument which my learned friend made in terms of Rule 13(5), he did not spell out the last para. I'll read the last para. He started with clause 5. The board, after examination of the documents and information furnished by the appointing authority, shall recommend to the appointing authority a list of officers about double the probable number of vacancies in order of performance found suitable for promotion. This part was not read. I am reading. In case the board does not consider an officer suitable for promotion according to seniority, it shall record the reasons thereof in writing and forward these reasons to the appointing authority together with the list. So seniority plays a very vital factor at all stages. Because seniority, I get the right from the gradation list, Rule 24, where it says seniority has to be cadre-wise. So the question is that if I lose also in the selection process on the seniority, which now I'm already lost, you have to record reasons. So my humble submission is that I still stick with the same argument. The cadre-wise selection, the rules envisage a cadre-wise gradation list that has not been made. As a result, through a procedure, indirectly they are trying to bring a catch-up principle, and in the resultant add chaos to the system because the catch-up principle is no more. Ajit Singh is dead. We need not take the arguments of Ajit Singh at this stage. Because if Ajit Singh was not dead, then why Nagraj, the Supreme Court upheld 16(4)(a) and B. And when it upholds 16(4)(a), Lordship, it means 77 and 85th Amendment. No one can take the benefit of accelerated promotion and consequential seniority. The learned single judge rightly said, power flows from Section 5 of the Act, the roster. When it's roster, it's not piecemeal. If you piecemeal it, the entire edifice of reservation falls, which is happening now on the OM coming in. This, if you remove Section 5 and remove the Amendment Act, the Act of 78, I don't have any case. But the fact that Section 5 still remains, the OM cannot override the Act and the judicial. That was my case. So in my humble submission, Lordship, my interim prayer is that since the seniority I have already lost, they have downgraded me, and till now there is no mention of any In fact, I fail to understand how my learned friend who is appearing for the respondent knows that I am not suitable. Has the selection commenced during the course of the day? That I don't know. So the fact that Lordship will call for the records, give the government a chance, give me a chance to give a reply. Lordship will fix it. I'm ready at any week, but during that time, that protection, one post, because usually these are the orders passed. Because on the earlier, Lordship has rightly said subject to when I came on the first occasion. But today I come into second position where I've already lost my seniority. That is my case. Under the
And
rules.
according to you, if the court says any promotion after considering all candidates, including you, is given, which will be subject to further order, then your right will not be protected.
It will not be protected for the simple reason because I have already come down. That won't help me because ultimately what I want that the seniority part they have to explain why I came down.
No,
Till
no,
now,
ultimately, if the court holds that your seniority should be in number 1 and not 17.
Yes, yes.
Therefore, promotion given to so-and-so is set aside. Then your right will not be protected.
Means, no, my lord, the issue is that they will now hold the selection because the gradation list, I have already lost one part. Because on the first day when I came, Lordship, I made a prayer that they might hold it. Rightly, your Lordship gave me protection, saying that it will be subject. Your Lordship added a last word, if I may say. Lordship will see 138. Having regard to the 138.
Yes.
Because your Lordship envisages something might happen. Having regard to the facts and circumstances of the case, I am not inclined to pass an interim. 138, Lordship.
Yes.
Can I read?
Yes.
Last part. Having regard to the facts and circumstances of the case, I am not inclined to pass an interim order at this stage, save and except providing that any decision taken by the respondent for promoting the departmental candidates in the matter in the Water Resource Department by giving effect to the OM would be subject to further orders that may be passed in this case. Because I made a prayer that someday they are going to hold a selection. And when they hold the selection, they will be acting on an erroneous gradation list in behalf the rules. That was my case. So Lordship has said subject to further. So today I'm in a situation where on the seniority I'm already gone. If your Lordship gives an order that I should be considered, then my seniority part is already gone. What will we do? The zone of consideration is not important. I want my seniority to be answered why I came down when the gradation list rules were very specific. You have to make it cadre wise. What was so special? You did not make cadre wise. And you could not have made cadre wise because my argument still stands.
So what do you say about Rule 13(4)(d)?
That has been amended now. Now it's seniority at all cadres. This is the latest. Rule 13(4). Selections for promotion shall be on the basis of merit with due regard to seniority in all cadres or posts. So the seniority part cannot be ignored.
Why not, Supreme Court has said, whether it is merit, whether it is merit cum seniority, whether it is merit with due regard to seniority, these are essentially all merit-based criteria. It is only when, my lord, merit is not equal, then, my lord, the seniority will come into. If the merit, supposing, my lord, my learned friend's client merit is more, and my client's merit is less, my lord, my seniority will not do. You will steal a marks, and it is vice versa. My lord, there are up to number
Yes,
of
yes, that's correct,
cases
that's
which
correct.
say, my lord, these are essentially all merit-based criteria. Let us not argue on the point, difference between a merit cum seniority, merit or merit, it's all merit. So if he has higher merit, he will get a promotion. If he has no merit, he will not earn a promotion. That's all.
So that is my prayer that since a situation has come where I have been downgraded in violation of the rules, I need that protection. At the same time, I am ready for an expeditious hearing. That's fine. I don't want to keep the matter pending.
My lord, I'll come to the facts a little later. My lord. My learned friend today also has made a submission that the catch-up theory has gone. This is one fallacious submission my learned friend repeatedly makes. My lord, in Nagaraja, the 85th amendment, by virtue of which they say that they are entitled to consequent seniority, the validity was upheld, and the Honorable Supreme Court has said that it is only an enabling provision. Only it enables the state either to go for a consequent seniority or not. Now, in the subsequent judgment, I will not read that, my learned friend will accept that. In the subsequent judgment of Paneer Sinwal, I'll just read two small paragraphs to say that the submission made by my learned friend is not correct. The paragraph 1 itself says, in the absence of policy decision taken by the state, rules framed pursuant to the enabling provision of Article 16(4)(a) of the Constitution of India, whether a reserve category candidate promoted on the basis of reservation earlier than his senior general category candidate in the feeder category can claim consequential seniority in the promotional post. This was the issue. This was the question, my lord. Now, Lordship will kindly see in paragraph 26, the answer has been given. The true legislative intent under Article 16(4)(a) of the Constitution is to enable the state to make provision or frame rules giving consequential seniority for the accelerated promotion gained based on the rule of reservation. Rule 12 evidently does not provide for the consequential seniority for reserve category promotees at any point of time. Stop. The consequential seniority for such reserve category promotees can be fixed only if there is express provision for such reserve category promotees in the state rules. In the absence of any specific provision or policy decision taken by the state government for consequential seniority for reserve category accelerated promotees, there is no question of automatic application of Article 16(4)(a) of the Constitution. My learned friend's submission is 85th amendment, which has inserted Article 16(4)(a), itself gives him the right to the roster point promotees to get consequential.
No, that's not correct. It's an enabling
Provision,
Yes,
and
yes, settle.
this judgment and BK Pavitra also subsequently said that it is enabling, and if the state takes a policy of consequential seniority, then catch-up theory will not come. In our case, my lord, by the OM of 18(1), we have made it very clear, which they have challenged, that it is the catch-up theory, no longer consequential seniority for this category of officers. Based on that, then gradation has been changed. Now you have to challenge the policy decision. You have to succeed in challenging the policy decision of OM of 18(1).
No, that is the problem. I have come across at least 3 or 4 writ petitions where Mr. Das
Yes.
is for the. I've been asking this question to myself.
My lord.
If that is his fundamental challenge, then how does he say that the single judge's order is in his favor? I have not been able to understand. How 6
The
is in your
single
favor?
judge's order is in my favor because in the Bhagwan Patar's case, clause 4 was challenged
Hmm.
because the state Assam government did not want to give us the benefit of merit. That was the challenge. In clause 4, it says that if you are the higher, if you got it earlier, you will not got. There is the single judge categorically relying on Supreme Court judgment says you cannot do it because it's violative of R.K. Sabharwal. On merit, you go as a member of the unreserved. You can compete. You cannot. There cannot be a quota for the general on merit, which the state of Assam is trying to do.
All right, that's one part of the
Yes.
order.
And
The
as
other
we-
part is the liberty has been granted.
Mala, liberty has been granted on the last occasion also. Mala, in my case, the OM part, because the challenge is already there, a detail the government will have to give because I've challenged the policy basis. Now, these consequences which are coming up, I'm told all departments are going on and downgrading all officers of the reserve. In the single judge's order, it was very clear. The basis of the OM, on the basis of which the government came up and brought in the catch-up principle to my case was they overruled the judicial order. The first line itself says, the single judge has said you can have or you may not have, but you can have or you may not have provided it is compliant Nagras and journal. There my case comes in, that this OM is not compliant Nagras and journal. So that is the case. The learned single judge
All right,
rightly said.
Mr. Das will examine the matter certainly.
Yes,
These are
yes,
heavy
that
issues.
part
Yes.
will, these arguments will come on.
When do you want it? Can
Can
you suggest a date when you
Yes.
want it?
Well, at any time, because the urgency is there. It could be a space.
And-
Well, Rachit,
and just one
the-
factual part, my lord. Out of these 8
Ajit ki
vacancies, 2 are reserved.
Hmm?
One is for SC
Sinner?
and other one is for ST,
7.
STP. He
Seven.
belongs to STH. So even otherwise, through this reserve category, he cannot enter. As a general candidate, he can always compete.
That's all right. We'll only say that you have to consider all the vacant
Yes.
posts together.
Yes.
Uh,
Yes.
That's all. we'll
And
say.
7, Lordship, on 7, Lordship can fix it on 16, Lordship.
16th of?
16th of February.
No. No question before 14th February, 14th March. Question, these are not that important matters.
Yes, your lordship will.
Have to file an affidavit. my lord,
Choose a date after
Yes, I'll
14th of
choose the
March.
your lordship. But lordship, if your lordship passes the order that they will consider, then my entire prayer will be otious because my prayer is on the seniority part because there is no answer from them on the gradation part. Then I lose out because they have brought me down and they will hold
Mr.
me.
Das, now I am very close to passing an order list before another bench. If you
No,
want it, then.
No, no,
I can pass.
why will I want it?
Because you see, I have heard your submission.
Yes, yes.
And now as a
Mhm.
judge, I have to exercise my
Yes,
discretion.
yes. Huh?
If you press hard on that, it will be very difficult.
Malad, can it be after the, then let it be after the Holi.
14th of March,
Yes.
14th March,
Yes, yes.
correct?
Well, let it be on 16th of March.
16th of March.
Yes.
But 16th March means 16th March.
Yes. Always.
I am not at all rejecting his arguments.
My lord, his lordship will
All I am
consider.
saying is this matter will require a little finer scrutiny.
Yes.
Maybe he has a case, maybe he doesn't have.
My-
But we have to give a clear answer to these questions.
Yes.
And only issue is at this stage, what is the interim order to be passed? So I'll dictate that order.
I'm
You're
not
free to accept
injuncting
or-
your lordship from passing a omnibus order, only my thing should be protected.
I have considered and I'll pass an order.
Yes, but I don't want that subject thing because subject thing has landed me into trouble today in moving the second petition.
But what order your lordship will pass will not depend on.
I'm not restraining
No, I-
them from filling up any
Yes,
post.
sir, that also I'm not.
That I'm
asking
not
for.
restraining them.
But at least my is till final orders, they may keep that part maybe.
How
Because
does
the
it
lordship
help?
has, because my
How does it
seniority
help?
part, that how will they? Because once they consider me on the selection, dehors the
No,
rules.
Mr. Das, how does it help you? You can only become an additional chief engineer or whatever it is if you succeed in first establishing that you should be senior. And then there is a consideration of your case on merit as well as on seniority.
In
count.
terms of the rules.
Right. So you have to first succeed in that, and then the order the court can pass. What a particular court will pass, we don't know. But what legitimately the court can pass is to consider your case on the parameters laid down in the judgment.
And the.
That is, according to me, the correct way of passing an order.
And the rules, because of the first day, the
Right.
lordship specifically said.
Rules will be on the, what is mentioned in the judgment is after considering the rules.
Yes, because the lordship.
So the
specified-
final relief that your client will be entitled to hear, if at all, is that his case for promotion to the post of additional chief engineer should be considered within particular time frame on the parameters laid down in the judgment. Nothing more, nothing less. So till the time you get that order, you can't become an additional chief engineer if you don't succeed otherwise in the normal selection process. Therefore, Mr. Das, please tell us, till that stage is reached, what purpose will be served by keeping one post vacant? You answer that question, I'll state.
Malad, what I personally feel, since your lordship is deciding the matter on 28, usually lordship is always very in giving omnibus orders and promotion. But in my case, until judicial scrutiny, that helps me till on the 24th.
That is what I'm saying. How does it help your client? How does it, except for
If your
ego,
lordship
how does
passes
it help?
The
you?
order that the selection will continue, will proceed. The fact that they have brought me down, will they consider my merit part? That I'm worried. That is the grievance.
We'll ask them to consider you.
Yes, then that part, if lordship, the merit part in terms of the rules is.
And you see, if they
Yes,
consider you and arbitrarily reject your candidature,
Yes.
you think the court will gloss over it?
No, but now is the time I'm moving to the.
Mr. Das, these are matters where
That-
I'm sorry, so much time in promotion matters, always that is the approach.
Lordship, I leave it to your lordship. Lordship will pass an order.
If
I can
you
make my
could have,
submission
if
only.
you could have shown that, no, unless if you keep that post vacant, by another door I can enter and become the.
Because I could sufficiently so that by subterfuge, they brought the catch-up principle and brought me down.
That is another matter, Mr.
Yes,
Das.
yes.
If it is directed to be kept vacant, how does your client get to benefit till you succeed in the writ petition? That's the only
Then I'll
question
leave
I'm
it to your
asking.
lord- Then I leave it to your lordship.
And if you succeed in the writ petition, do we not have the power to tell them that now You
Yes,
delete
yes,
one
yes.
name and consider him and,
Yes, only I wanted the DPC should consider in terms of the rules and the judgment.
and then you know the law. After consideration, you may never get a promotion and the courts can interfere only if they do not apply the criteria correctly. No court can direct any authority to promote an officer. That's the law.
Definitely.
So therefore, today, if you
Yes,
keep
yes.
one post vacant,
No,
how is
I-
it going to help you?
I'll leave it to your lordship.
No, you answer, you give me an answer, I'm willing to consider. The court is open to all possibilities. you
Because
see.
the reason is that on a similar set of facts, a coordinate bench has kept a.
Sorry,
post back.
sorry, I will not pass
No,
orders.
no, I'm not.
I want
Because it's
logic,
a
reasoning
coordinate
and,
bench, I
no,
can't
no,
force.
no.
It's only a.
We don't know
persuasive
what
value.
was the argument.
It was a persuasive value. I'm not, I got an order, so I placed it.
If you can even now,
Yes,
the fifth time I am
yes,
asking,
yes,
even now give me one reason
yes.
that if a post is kept vacant till the writ petition is decided, even then it will serve some public interest or your client's interest.
Well, the public interest of the government, what about my enforceable right? I have.
So, so in the meantime, you will remain additional chief engineer. Is that what you are saying?
No, I will not rebate. I am a superintendent.
Heard Mr. D.K. Das, learned counsel for appearing for the writ petitioner. Also heard Mr. D. Majumdar, learned additional AG Assam, assisted by Mr. R.M. Das, learned counsel appearing for the respondent numbers 1 to
1 to 4, I think.
1 to 4. Stop. No, okay. Can you please look at the petition and say
Well, 1 to 9.
1 to 9?
And I'm assisted by Mr. Aram Das because there are two departments, Aram Das and Ard.
R.M. Das and Mr. Ardhar for 1 to 9. Mr. K.N. Chaudhary,
Respondent number 14 and 20.
assisted by Mr. D.J. Das, has appeared for respondent numbers 14 and 21, full stop. By filing this writ petition, the petitioner has approached this court for the second time, being aggrieved by the gradation list in the cadre of superintending engineer bracket civil bracket close in the water resources department for the year 2022, whereby his position has been downgraded to serial number 17. Mr. Das, learned counsel for the petitioner, submits that the downgrading of the petitioner is dehodes the rules in as much as in the wake of the 85th constitutional amendment, there was no scope for the respondents to provide for the catch-up rule, full stop. To that extent, the interest of his client has been prejudicially adversely affected, full stop. It is also the submission of Mr. Das that if cadre-wise gradation list was prepared by the authorities, then in that event, there would have been no scope for the petitioner to be downgraded. There would have been no scope for downgrading the petitioner to serial number 17. Full stop. On such count, the learned counsel for the petitioner has prayed for an interim order protecting the interest of his client. Full stop. Mr. D. Majumdar, learned additional AG Assam, on the other hand, submits that the petitioner does not have any enforceable right in this writ petition as long as the OM dated 18/1/2023 holds the field and the rules do not infringe upon the rights of the petitioner. The relief claim for in this writ petition cannot be granted, full stop. Mr. Majumdar has further submitted that there are 8 vacancies in the grade of additional chief engineer in the Department of Water Resources, Assam, and
2 of them are reserved for, one for SC, the other one is ST.
full stop. According to Mr. Majumdar, 2 of those vacancies are reserved for ST,
SC and STP
SC and STP.
each.
Each, full stop. However, taking the ratio of 1:4 as the zone of consideration, the petitioner would also be considered for promotion against the aforesaid vacancies, full stop. Mr. K.N. Chaudhary, learned senior counsel, appearing for the private respondents 14 and 21, has further submitted that that for all practical purposes, the criteria for promotion is merit. And therefore, once the petitioner is considered for promotion, there cannot be any question of granting any interim order at this stage. First of, on the merit of the petition, the learned senior counsel has argued that the plea raised in the writ petition is wholly untenable in the eye of law. First up, after hearing the submission advanced by learned counsel for the parties, this court is convinced that the issue requires meticulous examination based on the pleadings available on record. In view of the above, issue notice of motion returnable on 14/3/2023. You want it on 14 or 16? 16/3/2023. Since the respond numbers 1 to 9 and 14 and 21 are already represented, no formal notice is required to be sent to said respondents. Extra copies of the writ petition be furnished to the learned departmental counsel. Stop. Petitioner to take steps for service of notice upon the remaining respondents by registered post with AD. Full stop. Heard on the prayer of interim relief, considering the facts and circumstances of the case, as well as the observations made in order dated 24/1/2023, passed by this court in WPC number 363, page 129 problem. 363/2023. I am not inclined to restrain the process of promotion, which is stated to have been initiated in the department. Restrain the process of promotion for filling up the vacancies of additional chief engineer, which is stated to have been initiated by the departmental promotion committee. First up, it is however made clear that promotion given to any of the candidates against those 8 vacancies of additional chief engineer would be subject to further order that may be passed in this proceeding. First up, the respondent shall also ensure that all the 8 vacancies are taken up together for consideration of eligible candidates coming within the zone of consideration. First up, register to list this case along with WPC number 363/2023. Mr. Das, you have an appeal task, but then you may have a point. Come up a little more precise on this.
Yes.
Because
In fact, Lordship, what will happen now, it happened in the earlier case also since I was dealing with it. Now, the fact that downgraded, just now I got an information that in the civil service also, it has, the catch-up principle has been enforced today. So now there'll be cases, but ultimately the OM challenge case will take the lead. So what I want that my learned friend should also make the stand clear, because once I can do away with the rule, then ultimately the position will come.
correct, there will be some.
So that expeditious part, I'm.
No,
ready
we
with
will
it.
do it. We'll do it. In the other matter, already some timeline has been
Yes,
fixed. So they have to file affidavit.
yes, the stand has to be clear.
That will.
The fact that we have, in fact, we have challenged not only that day, I was only got a chance for the whole day to argue on clause 4. Clause 3 is yet to be argued. In fact, I'm coming up with a challenge next week on the clause 3
Achha,
also.
you are again coming.
Yes, Malab, because there's no.
In civil service also.
Yes, yes.
So how many more?
No. This is an information I got because one of my client can always talk, but my learned friend can stop me from.
No.
Have the same situation.
A live streaming to of course. What is this matter?
But here we have challenged the award of the labor code, reinstating the respond number 5 and terminating the setting aside the removal order and all the consequential order passed thereafter. In terms of the award, the computing the entitlement of the respond number 5 and the Bakizai proceeding initiated. Now, what has happened, my lord? The respond number 5, while he was a branch manager of the bank, my lord, for a period, my lord, he allowed excess drawal to several OD accounts and which beyond the sanction limit. And therefore, my lord, departmental proceeding was initiated on 31/10/2012. So cause was issued. He was given chance to reply. And in the reply, he does not dispute the charge. He, however, tries to justify it that, yes, I did it, but it was as per the verbal instruction of the seniors. So it doesn't dispute the charge. Statement of allegation was given to him. He has submitted his reply. Thorough inquiry was done. Inquiry report has been given to him. Inquiry report copy has been given to him. On the punishment, he was being so cause again. He submitted his reply, and thereafter a termination order was issued. Now that termination order was challenged before the conciliation officer, but the conciliation officer did not act upon it because he doesn't come under the definition of a workman. Then he files an application under section 2A before the labor code, challenging the termination order. Now, in that,
This is an ex parte proceeding going on.
my lord, the respondent number 5, they were there all along the.
Mr. Dasgupta was there, I
Mr.
think.
Dasgupta and Mr. S. Chakraborty was there.
I'll call, try to call.
Let's see if they're around, otherwise.
He was there, in fact.
That's all right, you make your argument.
My lord. So the now departmental proceeding, after the departmental proceeding, he was removed. That was challenged before the labor code under section 2A application. The bank, my lord, they appeared, they filed an application raising the question of maintainability, that this application is not maintainable because he doesn't come under the definition of workman, and he admits that he was a branch manager. So definition of workman clearly says one who is not a managerial capacity. Now, thereafter, the bank stopped appearing in that matter. The matter went ex parte. Now, if your lordship will kindly find a very limited issue, if the lordship finds the award passed by the labor code, there is no adjudication done. Section 11A of the Industrial Dispute Act empowers the labor code to set aside a dismissal order. But what the labor code is required to do on the basis of the materials available on record, the labor code has to adjudicate, meaning thereby, my lord, the correctness of the removal order has to be, there has to be a conclusion to that effect. If your lordship will kindly find 214, the award, my lord. Just 2 paragraphs, my lord, from the award, my lord. How whimsically, my lord, the labor code has set aside this order.
Which page?
Page 214, my lord, the award starts. Model will directly come to page 216, my lord. 216, last paragraph. The workman has submitted the evidence on affidavit testifying the entire contents are narrated in the plain complaint petition and exhibited the aforesaid document. My lord, the exhibited documents are inquiry report, everything was there before the labor code. Now, the findings of the labor code at page 217. The evidence shows that the management removed the dismissed workman and there was a disciplinary proceeding against the workman as admitted by the workman himself. But nothing was produced about the result of the said disciplinary proceeding and not even about the charges of the said disciplinary proceeding. The management did not take part in the proceeding as stated herein above. Therefore, the veracity and the authenticity of the contents of the evidence of the workman has been remained unrebutted, unsecond indication in hand. Therefore, the workman is deserved to be reinstated with full salary during his period of suspension and back salary and other admissible benefit. Now, if your lordship will find their evidence or affidavit, everything was before the labor code, page 206. Even though, my lord, it is an ex parte proceeding.
But you say he was not a workman.
That maintainability ground is also there. But even though, my lord, that
What was the remedy for him then?
my lord, he has to come before the High Court or a civil suit or a civil suit. If he alleges, my lord, that there is a procedural infirmity in the departmental proceeding, then of course he can come under 226. Now, if your lordship will kindly see page 206, there evidence or affidavit. Page 206.
Yes.
This is the evidence on affidavit by the respond number 5. The page 208, my lord, will sign. Exhibit C, statement of allegation before the was exhibited. The email letter of inquiry officer. The memorandum of charges. The inquiry report, exhibit J, page 210. And the order of.
So,
removal.
Mr. Kaushik, what are your submissions?
My submission is, as everything, the entire record was before the labor court, my lord. Labor court ought to have adjudicated. If your lordship has seen, the learned labor court has set aside the order saying, whimsically saying that there was a departmental proceeding, the outcome of the departmental proceeding is not known. The removal is the outcome of the departmental proceeding. Now, to set aside an order of removal, the labor court ought to have adjudicated. That saying that this removal order is bad in law, it has suffers from procedural irregularity. There has to be a finding, judicial finding with regard to that. Well, section 11A, if I'm allowed to draw your lordship's attention.
Yes.
Which empowers the labor court to set aside a removal order. Powers of the labor court tribunal, national tribunal is to give appropriate relief in cases of discharge or dismissal of a workman. Where an industrial dispute relating to the discharge or dismissal of a workman has been referred to a labor court, tribunal, national tribunal for adjudication, and in course of the adjudication proceeding, the labor court or the transitory tribunal, as the case may be, is satisfied that the order of discharge or dismissal was not justified. It may by its award set aside the order of discharge or dismissal and direct reinstatement of the workman on such terms and conditions, if any, as it thinks fit, or give such other relief to the workman, including the award of any lesser punishment in lieu of discharge or dismissal, as the circumstances of the case may require. Provided that in any proceeding under this section, the labor court tribunal, as the case may be, shall rely on the materials on record and shall not take any fresh evidence in relation to the matter. So, my lord, this power can be exercised only when the labor court arrives at a satisfaction that the removal is not justified. And your lordship has seen how the labor court has set aside the termination order. No finding how whether the departmental proceeding.
So this award has been stayed.
Well, the award has been stayed. But this is, in my humble submission, this is a case which deserves remanding back to the labor court for fresh adjudication. As there is no power of review,
Let us quickly read the entire award. Which page is
yes.
it? Starts from page 214.
214. The proceeding has been initiated on the strength of a petition number 17/19 under section 2A subclause 2 of the Industrial Dispute Act, hereinafter referred to as the Act, by the workman with a prayer for full salary during his period of suspension, reinstatement with back salary and other benefit. It has been averred in the petition that the workman on 1/1/1987 joined the Industrial Cooperative Bank Limited, but he was dismissed from service on 8/2/2018, despite discharging his duties honestly, sincerely, without any blemish, for which he was promoted up to chief manager, HR and administration. The managing director of the bank management number 1 in the petition is the chief and the sole responsible person for all affairs of the bank. That on 29/7/2015, the management number 2, as an inquiry officer, started an inquiry against the petitioner workman for overdrawing in an account despite knowledge of higher authority. An inquiry officer, while disposing the inquiry, opined for framing charge through the disciplinary authority. The workman, being an employee of the Workers' Association of the bank, was elected as a general secretary, for which the management got unhappy and immediately issued a suspension order dated so and so without any reason. Thereafter, the management, while later dated so and so, intimated the workman that the earlier inquiry did not discharge, for which the opposite party number 3 has been appointed as a fresh inquiry officer. Being aggrieved, the workman prayed direction from the Honorable High Court. On being satisfied, the Honorable High Court was pleased enough to pass an order by Exhibit H for revocation of the suspension order against the workman, and also directed to continue with the disciplinary proceeding. But the opposite party number one, without execution of the order of the Honorable High Court, the rules of staff service, and during pendency of the reference case number so and so of the Labour Court, arbitrarily and illegally dismissed the workman by later order dated 8/2/2018. The workman also approached the Assistant Labour Commissioner and the authority twice, issued to the management for comment on the application of the workman, but nothing was done, hence this instant proceeding. The management, on the receipt of the notice, initially filed a petition 57A challenging the mandatory of the case without filing any written statement. However, the said petition along with the written objection was heard and disposed, rejecting the petition of the challenge opposite party and also giving chance for submitting written statement. But the management failed to submit the written statement, even did not take any step in case for which the proceeding has been proceeded ex parte against the opposite party. The workman has submitted the evidence on affidavit testifying the entire contention narrated in the plain complaint petition and exhibited the aforesaid document. The evidence shows that the management removed the dismissed workman and there was a disciplinary proceeding against the workman as admitted by the workman himself. But nothing was produced about the result of the said disciplinary proceeding and not even the charges of the said disciplinary proceeding. The management did not take part in the proceeding as stated herein above. Therefore, the veracity and authenticity of the contents of the evidence of the workman has been remained unrebutted and unshaken in the case in our hand. Thus, therefore, the workman is deserves to be reinstated with full salary during his period of suspension and back salary and other admissible benefits. Accordingly, the award is passed, setting aside the dismissal order of management and for his reinstatement in service with arrears of all benefits.
So according to you, the learned Labor Court was required to record findings on what?
Findings with regard to the correctness of the removal order. There was no findings with regard to the correctness of the removal order.
And he was removed in 2019.
He was removed in 2018. 8/2/2018.
And he's out of employment now.
He's out of it. Now he has retired. He has attained superannuation.
So what remains in this case?
Apparently, my lord, the departmental proceeding, there was no infirmity in the department. Even that is not their case before the Labour Court. They did not allege anything that there was a that they were not given opportunity.
Is any dues payable to him?
Yes. Yes.
That has been paid?
No, my lord. There
Why?
is a stay order, my lord, operating. My lord.
We'll close it, you pay him the dues and finish it off.
My lord, he is not in a position. My lord, apparently for this person, my lord, the bank has suffered a huge loss. And now the bank position is very bad, my lord. The management, there were discrepancies between there were several discrepancies. Management also, there were anomalies on the part of the management for which the bank suffered. RBI has to come in. RBI.
So, all right,
appointed
now
the
this, Mr. Dasgupta, this order of the tribunal cannot be implemented now. Reinstatement is not possible.
Reinstatement is concerned, that is not implemented.
So
That
what
cannot be
remains?
implemented.
What remains then?
Lord, in terms of this award, Lord, I have communicated the award to them. Not only myself, the government also communicated the order. I have only divided all this thing. Communicated this. They did not file any application whatsoever. They approached me. Then, my lord, as they have not computed, as they have not implemented this award, I went to the Labour Court for its execution. For the purpose of execution, notice were issued to them. They did not respond to that notice. Then the amount was computed. I also submitted the order passed by the Labour Court. They did not respond on that. Then also, as it was not implemented even after the computation, then I approached before the government for issuance of the Bakijai certificate. Bakijai notice was issued, they did not respond. Only when the certificate was issued, they have approved before the Honorable Court. Unfortunately, they made wrong statement before the Honorable Court. That aspect of the they have not approved before this put in a clean hand. Their plea was that the management was not aware of the fact. Their managing director was arrested.
So they were not aware of the fact. They only came to know only when this certificate was issued. Now, if your lordship, I have annexed all this.
So can you both agree on some via media? Or else I'll write out a judgment which will be either this way or that way. Some middle path, is it possible?
Yes, that can be done.
What are you willing to concede and what are you willing to concede?
That will have to take instruction.
Because supposing we affirm this order intact, we can do it if we want. Reasonings, we can give reasons.
If I'm asking, I'm not asking much, Malak. What I'm asking for is a fresh adjudication by the labor court, because I am.
That's
able
not
to-
happening. That's not happening because he has already retired. I'm not passing that order.
That apart,
There was a major punishment imposed on him, Malak. And he has not disputed the charges, Malak. If your lordship will kindly have a look at the reply. to
No,
his-
question of, you can forget the remand because he cannot be reinstated now.
Of course not, but if his termination is upheld, he's not entitled for the salary.
Now, what about retirement dues,
Malak.
service benefits, other dues, PF, gratuity, anything?
That he will be entitled for. That he will be entitled.
Why don't he agree to take those things and finish it off?
My amount was computed.
Sorry?
Amount was computed by the labor court.
Hmm.
And that amount amounts to about 30 lakhs and above, 35 lakhs above below. I gave it to the bank. Bank did not respond it. Then, my lord, I went for Bakijai proceeding. They also did not respond it. Then when the certificate was issued, they only came in. Another aspect is that is very, very crucial aspect. He was dismissed or removed when a case was pending before the labor court, where he was a concerned workman. Along, not only he, other workmen were also a concerned workman. He was a secretary of the union. Other workmen were also involved in that case. Now, section 33 stipulates that when a case is pending, where a person concerned is a concerned workman, or he is connected with the dispute, then you can dismiss or remove whatever you may like. You can do this thing. For that purpose, you have to take the approval. That is the mandate of the section 33. And that if you not take the approval, your order of termination or removal is void ab initio. Even if I assume that whatever my friend says, everything is correct. Then also on procedural aspect, that my order is void ab initio. I have two judgments of the Supreme Court. There is Jaipur Jila Parishad, there is a constitutional bench judgment. Yes. I've given the So,
Mr. Kaushik and Mr. Dasgupta, is a middle path possible?
Yes, that would be better, I think. Because otherwise, again, it will go
If
to
I have to
different-
write a judgment, I'll go very deep.
I'll explore the possibility.
Find out a middle path. Let's finish it. He is out of whatever has happened. Of course, you are entitled to say that, no, we want an order from the court this way. That you are entitled. And if you take that stand also, we'll go by in a fair manner. But I must tell you, the court is conscious that this man he cannot be reinstated back now.
And
He
this
cannot be
petition was
reinstated.
filed after his
So
rejection.
anything technically,
Regarding his service benefits, gratuity and all, Malak, that he is always entitled for. That I cannot deny also, Malak.
so then why should we go into
Only
this?
aspect is,
backwards.
Malak, as the back wages has been granted and the termination has been held to be bad. And therefore, the computation has been done based on the entitlement of award. It's a consequence of the award.
Yes, Mr. Chakraborty,
And
any
regarding
instructions you have? Give up something and get something peacefully and leave whatever is there.
Well, not for that, I have to take instruction from my lordship. What I feel, my senior also feels, lordship will give this matter part and fix a date.
Tomorrow.
Not tomorrow. That man is not available tomorrow, I know. So next,
Forget the back wage, we'll ask them to pay the rest. And
why not?
within 2 weeks. See, because if you don't succeed, then you have a huge amount.
Yes,
And you have no other way but to go to Supreme Court.
I understand.
And you see, these matters, a workman or whatever he is, then Mr. Dasgupta has raised a plea of issuing the order of removal without the permission of.
Well,
the-
that is the very. If I'm allowed to answer that, my lord.
Mm.
This departmental proceedings initiated in the year 2012. And the reference, which is not connected to this dispute, was initiated in the year 2017. There is an order of this honorable court directing us to conclude the departmental proceeding within a period of 2 months. In that reference, one issue was raised by him, that is with regard to suspension without issuing a notice. That was answered by the labor court. Answered by the labor court that it is an afterthought. They approached the Honorable High Court. High Court set aside the order of suspension, and therefore nothing is to be answered. This reference is the departmental proceeding is not initiated during the pendency of the reference. It was initiated long back. It continued all the long, and during that period there was a reference. And on even
Are you willing to forego back wages?
That is difficult. Some, we can forgo some portion. But full backward is then otherwise meaningless.
What is the back wage now?
No,
Computation?
total amount is about 35 lakhs.
Hmm.
So we can negotiate, or we can inform our client that the desire of the court, definitely when he earns that is the desire of
No,
the
no,
court.
because what I'm saying is,
That can be
he
negotiated.
is already, he cannot be reinstated now.
Yes,
of course
yes,
it cannot be.
We are not going to go into the validity. We'll just close it.
Yes, yes, that will be better.
I'll also try to take instruction on that.
Some sort of instruction.
The position of the bank is very bad now, madam. That's the only concern. And even I have been given the profit and loss account of yesterday. The bank is already at loss. And because of these anomalies which has been created by the respondent number 5, the bank has suffered
Is there any criminal proceeding against him?
nothing.
Well, actually, position has gone down due to the bank managing director. He was arrested.
And all were in collusion.
So it is better not to open the card.
Yes, yes. Because
I have
my
to
lord, the
open, I
management
have
is
to
no
open
more
so
there.
many things.
The managing director is in jail or outside?
He was in jail. Now probably he is on bail.
In fact, my lord, this petition, the Reserve Bank of India appointed the petitioner number 2 as the administrator to control and run the bank. There is no management now.
And
There is no management.
actually, this is the bone of contention. He was the general secretary. He raised so many objection, and probably that is the reason for his implication.
Anyway,
is the case of
Mr.
victimization.
Kaushik, I know your difficulties, but you have to take a call. Otherwise, we'll
I'll
pass an
try.
order.
I'll try to explore that. My lord.
We'll pass an order. When do you want? How much time? 10 days?
10 days.
Hmm.
10 days.
Come up with something
I'll
concrete,
try that.
and you also have to be ready.
Definitely,
Mr. Chakraborty can coordinate with you.
Yeah, I'll do.
I can talk to my client.
No, you talk to his number. Why don't you also talk? We'll make the provisions in the order of the court.
Yes, that will be easier for us.
This is a different kind of mediation, take it that way. You must convince your client that
Yes, we shall try our best.
he stands to gain something if he gives up something. And same is the case here. We don't know. I have not applied my judicial mind
My-
wholly. But
I understand.
what has struck me is that he cannot be reinstated.
It will be
What is
better
the
for my
point?
client also, because he has to fight again, writ appeal, again Supreme Court,
Hmm.
again return back, again then he has to computation, all these things will take more than 10 hours, 10 years.
So he
I
has
have
to
to-
understand this.
But the only difficulty is, my lord, to convince him to.
No, that's what I shall try.
It will be difficult to convince him. to
You do
follow
it.
the-
You are the best person to do it. Heard Mr. B. Kaushik, Learned Counsel appearing for the writ petitioner. I also heard Mr. A. Dasgupta, Learned Senior Counsel assisted by Mr. S. Chakraborty, appearing for the respondent number 5. Mr. C. S. Hazarika, Learned Government Advocate Assam is present on behalf of respondent numbers 1, 1 to 4. First, heard in part let this matter be listed again on 23rd of February 2023 for further hearing.
Malab, may I pray for that observation, Malab, with regard to the litigation, Malab?
In
Then
the
it would-
meantime,
Malab,
learned
yes, that will
counsel
be better.
for
That will
both
be better
sides
for him.
to obtain
And it will be
instruction
better for me also.
as to whether a negotiated settlement of the disputed issue is possible in this case, even at that stage.
That will be better for me also.
High level.
Petitioner respond number 5. Your Lordship.
Oh, yes, negotiation is petition respond
Petitioner
number
and
5.
respond number 5, petitioners and respond number 5.
Yes, yes,
High level.
high level.
Whether a negotiated settlement of the dispute is possible even at this stage. Yes, what else? Huh?
Petitioner remove from service after a recommended proceeding manner. There is another challenge.
Hmm. Remove from service.
Service, my lord. I'm giving a brief outline, madam. It's a long history, madam. 2002, he tendered a resignation, madam. Petitioner tendered resignation in due manner, madam. He was released from service, madam.
Service, what service? Which service?
He was serving in HPCL, madam, Hindustan Petroleum Corporation Limited,
Hmm.
as ballot executive operation, which is equivalent to deputy manager rank, madam. So tender the designation, which was not accepted, because some loan was pending against him. But though it was not accepted, he was not allowed to join. Meantime, my lord, VRS scheme came. He opted for that, that was also not given to him. In that situation, he wanted to join, he was not allowed to join, he filed a writ petition. While the matter was pending, there was a verbal assurance from the corporation that if he withdraws the writ petition, this consideration will be, it will be considered whether he'll be allowed to join. So he withdrew the writ petition on that assurance, but finally he was not allowed. He filed a second writ petition. Second writ petition, the learned signature finally held that because the corporation's stand before the writ court was that he was no more our employee. Employer-employee relation has been broken. So finally, the judgment was given. This court held that since resignation was standard, it was not accepted. Before that, he wanted to join. So he continued to be in service of the corporation. Matter was taken in writ appeal matter by the corporation. No interim order was passed. In fact, there was an observation that contempt is to be drawn why the single judge's order was not complied with matter. In that situation, again, they went to Supreme Court. SLP was rejected. Finally, my lord, in 2009, I was placed under suspension in a way that I was taken back in service in the form of placing me under suspension. Then, my lord, proceeding has been held and I have been removed from service. The first charge is from 2002 to 2009, I remained unauthorizedly absent, my lord. The facts I have placed before lordship, my lord, they will show that, my lord, they were bent upon not to allow me to join, my lord. I filed 2 writ petitions, writ appeal, SLP, my lord, and thereafter they have placed me under suspension. Therefore, on the basis of these facts, my lord, the charges they have drawn against me, my lord, there was malicious and arbitrary, my lord, only to harass me, my lord. So this is about the first charge. The second charge is that, my lord, while I was not allowed to join, my lord, and they asked for payment of the housing loan, which was standing against me. I wrote a letter to them that I'm doing some business, give me some time. Now, in that situation, they have taken the charge is that how can I do business when I'm in service with them, my lord? Whereas in the affidavit they have filed, they have said that there is no employer-employee relationship. He is no more our employee, my lord. 2002 to 2009, single farthing has not been paid to me, my lord. I have to sustain with my family, my lord. So this is the second charge. The third charge is the housing loan that I did not pay, my lord. Housing loan was, my lord, 5 lakh and odd, my lord, which I took from the corporation regarding buying a flat. Ultimately, my contract with the promoter failed. I could not. So management deemed it fit that I should have returned the money. It is correct, my lord. But Lordship, kindly see, they have drawn from me more than 18 lakhs. For that 5 lakh, they have drawn, I will give the calculation, my lord.
Yes.
So these are three charges, my lord, which are apparently not maintainable on the basis of the facts on record, my lord. So I challenge the removal on this count, my lord. Statutory appeal which I filed, my lord, I have given 2 legal notice, my lord, they have not considered. So finally I came to High Court.
This matter will take some time.
Lordship.
I've given the brief outline, my lord.
All right. You want to, can you finish it off today?
Not finished, my lord, maybe part hard, my lord. Zone 13 matter is not taking place, my lord. Number of time, my lord.
My lord will keep it part of.
All right, you argue for another 10 minutes or so, then maybe we have to rise a little early.
Lordship,
There's some-
meeting is.
There's some meeting has been convened, important meeting.
We can start, it is not
Mr.
convenient.
Das will know it, Mr. Nair will know it.
Lordship.
In that case, only if your lordship gives me a short date may be given, my lord. I am not that way, my lord. Because 10 minutes, even I will not be able to finish the facts also, my lord. And submission is more or less this, my lord. On the basis of the facts, the charges are.
We'll have it on 16th then.
Lordship.
16th fixed matter. Other cases will have to postpone. I'm not starting any hearing today.
Only so item 17 is some emergency because on the other day.
Yeah, but the reason why item 14 has been adjourned, now
I fix a short day, that's all my understand my. Because it's going to be.
item 17.
17.
All right.
I understand.
17 will be taken up on 21st. 21st, Feb.
No.
Item 16, my lord, it's registered, my lord, family bench matter, my lord.
21st.
Yes, 21st, my lord.
The case is.
Yes, you want to say something? Mr. Borwa,
Yes, I am, I was representing. 16, my lord.
21st will do it. There's some activities lined up for which I need to pay attention. All right, any other matter where date is still fixed? Mr. Das, you are for some matter?
I'm the respondent.
Achha. We'll do some hearings next week then. We have heard some matters to